Although this is a very urgent matter, may I pray that the admission seats all will be filled up. I am in merit list. May I pray, my lord, have you taken up today for lordship's rights?
Yesterday you had moved that matter.
That matter, my lord.
It has not come today. It is posted day after tomorrow, no?
My lord. So she is saying that all the seats will be filled up. That's why I am constrained to make a merit. That's the last.
Two.
My lord, the matter was day before yesterday. You should notice. But in the body of the petition, the date of the annexation has been wrongly typed. I just want to correct that. I filed IA tomorrow, my lord, so that it will be corrected. Notice will go.
No.
My lord,
Tomorrow.
the petition of the retired class 4 employee. The matter was listed by order of lordship.
Which year matter?
23 men.
23.
It was listed on 6th August.
After 2 weeks it will come.
My lord, it was listed in this court.
You have said that. I have noted. Because we have already fixed dates. After 2 weeks it will come.
My lord, trust.
2023, my lord. Recovery matter.
Monday, my lord.
No, not possible.
Recovery matter 2023 fresh admission. Elect or not, my lord.
Next question.
Pardon to mention, my lord. Fresh admission matter 2010.
Fresh admission.
Segment memo I filed. Review petition 2019. Review petition 2019 method.
2019.
19.
Call next.
I beg to pardon. Next week, my lord.
Yeah.
Next week.
I beg to pardon, the matter
Next week.
of 2024, my lord. I am for the opposite part of 5.
When do you want?
Lordship, this is because I am not able
I am
to.
asking a question.
Can it be next week around 26?
All.
On 26.
Next week.
Admission matter. 26.
Take all the fresh admission matter.
My lord, FAO matter.
First admission, na?
Sir, I am.
Yeah, next week.
My lord, FAO.
Before your lordship, it was to come after 2 weeks, but it is not listed.
Which year?
2024. But from 2016, his 3 writ application has been disposed of on the RACP matter. This is cover matter.
Take that next week.
Pardon to mention your lordship.
From this side, so that we can have this one. Officer cannot move to your.
My lord, FAO matter taking up on Thursday. My lord, in this case, he is not getting granted. The school is not getting granted. He has already made a representation, but the notice has been issued. So, dispose of only direction will be given to the secretary. That is my prayer only.
Pardon to mention, my lord.
The pleading here, another matter is that another sir, the person has
Year matter.
the 24, but he has been offered by this order of this Hon'Ble court has been offered by the division bench and appeals court, but they are not regularizing.
Week after next week.
Pardon to mention, my lord.
Next week, sir.
Week after next.
Pardon to mention, my lord. 23 matter, my lord. Pleading has been complete, my lord. Pleading has been complete, my lord.
Readings complete.
My lord.
All 2 weeks.
Pardon to mention about this matter is pending since 2024.
When do you want?
Next week.
2 weeks after.
And another matter is of railways where the petitioner has taken the stay.
Both 2 weeks. So,
One that I may pardon. One matter was listed on my mention on 12th August, but it could not be taken up due to non-vision of a serial. So may I pray let it come
which
next
year?
2024, man.
24.
Yes, man. Malas, this is a promotion matter. The meanwhile, the petitioner retired and
Already has retired.
no, retired, my lord.
I mean, pardon me, Lord. Item 52. This matter was there before yesterday. The Lordship was pleased to give me a task that with regard to the study that
Come back.
I have got that book. I need some more preparation. I have the book, my Lord. I need some more preparation.
That JP Singh House.
Yes, please.
Other books you did not get.
No, I get. I have called for, but
Call 2 weeks. Call.
Item 66. Item 66. Yesterday I have received the counsel. I faced some time to I file a rejoinder.
But inform the other side. Government is some judge.
Government is the other
till
side.
evening.
Government is the other side.
2 weeks. Item 70, madam.
Item number 20 fresh admission. I prefer to 1 week time.
25. Which year madam?
2025 matter.
25 matter. 3 weeks.
Item 20.
Item 70, madam. This is standards matter because they will yesterday. Can you dispose of the opposite party have informed
Any time comment?
Any other day? Today.
Sir, yes, no,
Is it
that's
posted today?
Yes, it is posted today. The item, last item in the board.
Let us see.
But at 2 p.m. we file.
Let us see. What is the urgency?
The students' revaluation, they have done certain question, they have left out certain question. Only a direction I want, but let them get needful. So far the other questions are concerned. I have got the answers from them. System.
You mentioned by 3 p.m. Let us see.
Again, I have informed the other side.
Number one.
And the petition of health is application for awarding him gold medal in the year 1999. In the year 1919, he has secured highest mark in the college medal. But on 2022 onwards, gold medal has been awarded, but the petition was not awarded in the year 1919.
Whether any policy changes? Who appears for the university?
I am appearing for the university, my lord.
What is?
My lord, the convocation is over of that year. And gold medal has already been awarded. But he has not approached the authority. Let him first approach the authority to take a decision.
Begging, give me a gold medal like that.
No, my lord. Because he has passed out in the year 2019.
Correct.
And now it is 2025.
All right. Why you did not give the gold medal?
For that,
Gold medal is being given to boost those who want to be knowledgeable.
for that year, that is already over, my lord.
That year, why did you not give him? Where is it?
I will file an affidavit to that effect, my lord, because my instruction is that
What we should do with your instruction, unless you file it in a form of pleading?
yes, I will file it in the form of 2 weeks time may be granted me to file in.
These are the awards meant for honoring the great intellectuals.
Yes, my lord.
They don't come with a begging bowl. Give me some gold medal, silver medal, bronze medal. That is not the way.
Because in the subject he claims, we have to find out is that subject is coming under that purview of the gold medal or not.
Well, you should find out.
So
It's your duty.
Yes, my lord.
The university.
My lord.
What our scriptures say, Vidwan Saraswati Pujyate. It is one such thing.
My lord.
When will you file your objection?
2 weeks time.
2 weeks finally granted to university to file its counter. Failing which right to file counter stands forfeited and petition will be taken with face value. Okay.
Item 2.
Next.
My lord, there are a batch of people.
Yes, sir.
Those services were terminated illegally without following the principles of natural justice. One batch of the people, those who have been before the coordinate bench, the coordinate decided, I am giving a copy thereof, that will be made applicable.
I am appearing for the opposite party, my lord, through caveat, my lord. Here in the case, my lord, that batch has something different. And in that case, my lord, the very pertinent question of maintainability of the read has not been decided. This is a purely private institution without getting any aid, the college is functioning. So the preliminary question objection is to maintainability.
Whether you were a party there.
Yes, there are parties there.
You were a party.
Yes,
You have preferred that order.
but
You did not raise that point there.
no, that point was raised. Orally that was raised, but no counter has been filed because the court has passed the order and against that read appeal has filed.
You filed writ appeal, you
Yes.
challenged this.
Here, my lord, what happens here, my lord, we have followed the procedure. After following the procedure, termination was issued.
Show that.
Your lordship must see. They are own.
Did you give the opportunity of
Yes,
hearing?
lord, we have issued the so called notice. They didn't appear before the committee.
That's the first time it has come today.
First time.
They let him accept notice.
Yes, lord. I will file. Your lordship will grant me 3 weeks time. I will file my reply.
Why 3 weeks? You are waiting for 1 week.
No,
Rule 11. Only 1 week in your state. It's a weak rule.
it's not that
It is a prescribed week and it's a very weak rule. Because weak judges. Yes.
You are done.
My Lawrence friend has got the copy about 15 days back. Now he's ready. Why is not filing the counter within
I
a week?
already instructed them to send them the copy to give us the paramount along with your documents so that we can.
No, but a copy of the petition was served on you much earlier.
Yes.
We have not filed any objection.
No, I have already copied them to all documents. Verify the alter
No,
documents.
what all happens between you and your client is not our issue. They have served it 3 weeks earlier.
Yes, sir. Sir, can be earlier.
3 weeks. Therefore, we'll issue the interim order.
No, interim order, the termination order has already been effected.
If it's not termination of governor,
No,
it's simple. What is your client doing?
My lord, we are out of employment.
So when were you terminated?
My lords, we are working with that pharmaceutical college as teachers, clerical staffs, and transport employees.
When were you?
15 years we have been working.
You are not answering question.
Yes, my lord.
When were you terminated?
When termination took place only, my lord, 2 months back.
already 2 months back now, they have
In July.
fresh advertisement was made and fresh persons has been appointed.
In all the.
No, they cannot appoint, my lord.
Fresh persons has
But you have not filed objections even after 3 weeks.
You lost my grant me.
No, I will not grant.
Only 2 weeks I will file.
We'll grant interim order, you file it whenever you want. Why advance copy is given to you? The KVA? So that we can file. It's not for waking you up from the slumber.
No.
It is for filing objections.
You lost my grant. You lost my grant 1 week only.
No, that is 3 weeks. What did you do?
No, you lost my grant 1 week I will file.
No. You otherwise you pay 25,000 rupees cost will give you.
But it's for the first time it has stopped.
First time it is done, but therefore I am giving you interim order.
Earlier they have taken the
That's not
time.
the-
I am not taking.
That is not the rule. Rule says where KVA is filed, they should serve a copy of the KVA petition on you in advance. You give the objection statement before it comes before the court. You have not filed any objection statements. You slept over the matter with the petition as a pillow.
Lost grant 1 week time I will file my reply.
You pay, you are for the university, college.
College.
You pay 10,000 rupees fine, will give you. Learned counsel for the petitioner, learned senior advocate appearing for the petitioners, vehemently presses for grant of interim relief. First, it's a coordinate bench decision.
Yes, my lord.
That decision where there is no process has been taken
You
place.
have said that. All this you should have stated in your objection statement. You have not said that.
I was corrected for your lord's convenience.
WP number 16129 of etc. of 2025 between Udit Kumar Hui versus State of Odisha, saying that relief has been granted in a series of matters against the very same college.
Yes, college.
Very same college.
Pharmaceutical college.
First up. He also points out that copy of the petition was served on the concept representing the college 3 weeks ago.
No, 3 years.
How long?
15 days.
15 days ago.
Okay.
15 days.
Okay.
First. However, no objections are filed resisting the prayer for issuance of interim order. First. A prima facie case has been made out for issuance of the interim order, especially in view of the coordinate bench decision referred to above. First, in the above circumstances,
The court has not.
respondent college is directed to continue the petitioners in service till next date of hearing.
Yes, lost the grants.
If this interim order is not complied with, then the defense of the respondent college may be struck off.
Just to your lordship, this is not an interim order. This is not an interim order. This is a final order.
Therefore, interim order granted.
This final order was issued. Lordship, hear me for a moment, below. Hear me. Your lordship, hear me for a moment.
You have heard so. You have not argued anything worthwhile.
This order was
the final order.
the final order because the court found that no procedure of natural justice and other things has not been followed.
Correct.
And that is why
Now-
court has finally.
Now I have passed. Maybe I have wrong order. I have passed. You have remedy.
No, that.
Next.
Next.
Item 3.
Item 3, may I please, Your Lordship? My lord, here the
Otherwise, your lordship may find the same order.
No.
If
You can't dictate to the court.
No.
You can make submission. Then you made it. That submission is not worthwhile. Therefore, I contingent demand.
my humble submission is,
Item 3.
Item number.
yes.
your lordship may just add my submission.
You can't.
Take
This will be too much. Understand? Stop now. Yes. Next matter.
Item 3.
May I please, Your Lordship? My lord, here the petitioner was working as a headmaster.
Yeah.
Now, Your Lordship, what happened was that there was a case in a village with the Narcotics Act, Your Lordship. The petitioner's name was never named in the FIR, but a communication was made by the IIC, the inspector in charge, to the district education officer at Annexure 3, because of which, my lord, he was placed under suspension at Annexure 4 on with effect from 7th of April 2025. My lords, the charge sheet and the cognizance order, my lords, I have annexed. In the charge sheet, my lords, the name is not reflected, Your Lordship, and in the cognizance order as well, my lords.
In FIR, your name was.
No, Your Lordship, it was neither in the FIR nor in the charge sheet it was reflected, but only basing upon a communication made by the inspector in charge to the district education officer, my lords, I have
What
placed
is
on
it?
suspicion.
My lord,
Investigation.
investigation is still open.
This is charge sheet.
Charge sheet has been filed, my name
My
is not
lord,
reflected, my lord. But investigation is not open in my name, Your Lordship. In name of other two accused persons, it is here and more.
Is slow.
My apologies, my lord.
173(8) report is filed.
Final form they have filed, my lord. No, Your Lordship.
Not filed.
But in the charge sheet, my name is.
The charge sheet. 173(8) is charge sheet. Yes. Saying that charge sheet is filed. The word charge sheet is not found in CRTC at all.
No, yes, my lord. But, my lord, it is continuing for more than 90 days, Your Lordship, and investigation, my lord, in the cognizance order.
You are only jumping from one point to another. I am asking you, where is the charge sheet?
My lord, the final form, my lord, has been filed at Annexure 5 series, Your Lordship.
These are 5 series.
Yes, Your Lordship.
Show that.
It begins from page 25.
5.
6 series, my apologies. 6 series, Your Lordship.
6 series.
Yes.
First page of that report is where?
Yes, my lord.
How
From
does it read?
My lords, kindly see page 1 to
120?
7.
1 second. He's showing something.
yes, my lord. In that, from there, my lord, in the
Border previous connection cases, the station of the accused of accused. How many witnesses have been examined?
my lord, my instructions are
No instruction. You have to show it from the papers.
yes, my lord.
Because you are referring to the charge sheet.
Yes. My lord, if Lordship may kindly peruse page from 71, it begins from 71, the particulars of witnesses. My lords, there are around 22 witnesses, Your Lordship.
Have they been examined? Only cited.
Yes, Your Lordship, they have been cited.
Whether 164 statement is recorded. Do you know anything about the CRPC?
One is not recorded.
Then where is the charge sheet?
But my lord, my name is in the cognizance order, Lordship.
It is still, matter is still under investigation. Nah? Once charge sheet is filed, you come back. I'll give liberty to you. Within what time you have to file the charge sheet? within 90 days. Where has he been named? In which document he is named?
My lords,
You?
My lord, I am a headmaster placed under suspension, your lordship.
Under NDPS?
Yes, your lordship. But
my lords, there was a raid. And the villagers, along with this person, they assaulted the police officials and officers.
He also assaulted.
That was.
Any name is found anywhere? Anywhere. In any document.
My lords, Annexure 3.
Annexure 3.
Annexure 3. Page 21.
Where is his name?
With reference to above cited cases, the subject used to intimate that the assistant teacher Narendra Naik, this is present petition. Now headmaster is involved in criminal cases.
This is sent by whom?
This is by the police inspector.
What is this document?
my lord, it is an interdepartmental communication between the IAC as to the district education officer. But in the FIR, my name was never named. Only on the basis of this.
Lodged the FIR.
My lord, FIR was lodged by the police, the sub-inspector, because of police in the...
Does it include X, Y, Z, etc.?
Yes.
Or only X, Y, Z?
My lord, in the FIR, my lord, certain persons are named at page 16.
And others is there.
Other 200 villagers, my lord.
Then you are also villager only.
My lord, I am not the villager, my lord. I am working in a school at a particular place, your lordship.
In that village?
Not
you
in
are
that
from
village.
which village?
My lord, I am working in the headquarters at PDR, but I do not belong to that village, your lordship. And in my name, my lords, what has happened is only on the basis of the communication, my lord, I have been suspended, your lordship. And this
When were you suspended?
7th of April 2025, your lordship, which is at Annexure 4, your lordship.
7/4/25.
Yes, your lordship.
My lords, contemplacy disciplinary proceeding, my lords.
Is
there is a proposal of disciplinary.
What in D also?
My lords, kindly see Annexure 4.
Annexure 4. 7/4, now 7/8 is over, 17/8 is over. What is the progress? Which is the judgment of the...
My lord, as per the Ajay Kumar Chaudhary judgment,
give that.
what is the verdict again?
6 months or 3 months?
My lord, it should not extend beyond 90 days if in the meanwhile the memo of charges is not served, or what is that?
You give representation attaching this
Lordship. As lordship
that may help you.
As a lordship, yes, ma'am.
But Ajay Kumar Chaudhary,
Yes, your lordship.
he is in a particular rule position.
My lord.
I do not know, you are not assisting me in your rules. How long you can be kept under suspension?
My lord, as per Rule 12 subclause 5, your lordship,
Rule 90 of the service code.
90 provides for suspension.
Rule 12 subclause 5 provides for the suspension, and Rule 90 of the service code, it says that it should be reviewed for 6 months.
Periodically, it should review.
It should be reviewed. But my lords, what has happened here is that I am yet to be provided with the memo of charges. If there is any disciplinary proceeding, I am willing to face it. I am cooperating with the investigation, your lordship. But as per the Ajay Chaudhary judgment, my lords, if the memo of charges is not issued, and my lords, in the documents which have been filed before the learned court in session,
Anyway, you give one
to
representation.
the opposite party for your lordship.
OP number?
4, your lordship.
A headmaster of a school under suspension is knocking at the doors of State Court, seeking its revocation, stroke quashment. First, learned counsel for the heavily presses into service Apex Court decision in Ajay Kumar Chaudhary versus Union of India 2015, 7 SEC 291, to contend that the period of suspension cannot be elongated beyond 90 days, and his client having been suspended with effect from 7/4/2025 that period is already over. Despite that, no action is taken for rescinding the said suspension. First, he also quotes Rule 12,
Subclause 5
Rule 12.5
of OCSCCA rules, Your Lordship.
Rule 12.5 read with Rule 19 of
Odisha Service Code, Your Lordship.
Orissa Service Code in support of his contention. First up. Next paragraph. Learned AGA, one more sentence. He also points that the investigation having been already accomplished by the police, charge sheet has been filed, wherein petitioner's name does not figure. First up, he hastens to add that the name of petitioner does not figure even in the FIR. And therefore, there is absolutely no reason or right for suspending his client, or at least for not rescinding the suspension order in the circumstances. Next paragraph. Kindly be seated. Learned AGA, learned AGA appearing on request appearing for the respondents submits that it is always the prerogative of the employer to place an employee under suspension in contemplation of disciplinary inquiry or when a criminal case is pending. Ordinarily, the writ courts would not grant interference in matters like this, in as much the suspended employee will get the subsistence allowance, and that if he emerges victorious in the punitive proceedings, he would get everything back. First, he also adds that the petitioner has been kept under suspension because of his name being figured in the interdepartmental communication between the police and the other authorities. First, having so contended, when faced with the apex court decision in Ajay Kumar Chaudhary, he in all fairness submits that if the petitioner makes an appropriate representation coupled with documentary evidence in support of his version, there will be no difficulty for considering the said representation in accordance with law and in a time-bound manner. First up, with this proposal, counsel for the petitioner is agreeable. First up, in the above circumstances, petition is disposed of, reserving liberty to the petitioner to make an appropriate representation immediately. And if one be made, the jurisdictional authorities shall consider the same and inform result of such consideration to the petitioner within an outer limit of 2 weeks. Within 2 weeks, you have to take his suspension. Continue or not to continue? Simple.
4 weeks, because we will communicate that.
Three.
It takes time.
All contentions are kept open. Next, open to solicit. Let's bring paragraph. No costs. Item 4.
The petitioner moved before this now, this was directed to consider his case. Now the government has consider case for promotion. He is given to similarly stated. Now the opposite two has rejected the same on 5/5/25. I have challenged that rejection order.
On what ground?
On the ground that I am not eligible to get promotion.
Yes, if you are not eligible, how to get the promotion?
Supreme Court has confirmed that I am eligible.
Is it?
Yes, similar. The land tribunal directed to give promotion to the applicants and other similarly situated teachers. Against that order, government moved before this on the court. This on the court has rejected.
Take notice.
Yes, that is fresh matter.
Issue emergent notice. Learned AGA is requested to accept notice for OPs. Since a short point is involved, call this after 4 weeks.
9 and 10 also.
9, 10, say. Yes.
Item 5.
My lord, may I please?
Yes.
One virtual good, my lord.
Yes.
I filed for information, right to information for the petition number 9, who had engaged as a teacher in the school of Lanzigarh, and RTA had given me any information. Then I filed an appeal before the state commissioner, RTI at Bhubaneswar. There also I did not get any information regarding about the petitioner 9.
Why is so much complicated prayer columns in this court? To understand the prayer column, I have to call Salmon here. Simple case. Quash the transfer order. Certiorari. Direct the respondents to consider my representations. Writ of mandamus. Issue notice. Ask them to show cause. If they fail to show cause, then do this. All that jugglery is not necessary. Simple. Writ of mandamus. Issue a writ of certiorari, issue a writ of prohibition, writ to habeas corpus. Why? How to understand your prayer? I have to call Webster to understand your prayer. In every case it is happening. I do not know. Where from you have learned these things? Because I have good exposure comparatively to the literature, law literature. I may to come across such prayers. In every case, prayer is so cumbersome. The citizen, is it your intention to make your client not to understand what you are writing, apart from the judge? You can torture the judge in a different way than by this language. What do you want, sir? Why are you here? Keep your prayer aside. What really you want? What order you want?
I need the information from the RTI against the petition number 9.
Petitioner number 9. Who are you?
No, sorry, opposite but 9. I am the petitioner.
You are a petitioner. Why you want?
I need information against opposite party number 9.
About why? Why you want that information?
Because he engaged a teacher without any document.
Now, how? Are you a contestant for the post of the teacher?
No. I only needed the only information against the teacher.
He wants some information, brother. You give one card.
My lord, it is a private dispute between two persons. And RTI.
No, this is extended to RTI, extended to aided schools also, na? There are judgments of many.
This application is under the RTI Act.
RTI Act.
Yes. Whether that is assigned or not, kindly.
No, anyway, just you consider his representation and instruct your officials to give one cartload of one auto full
My lord,
whatever
the allegation is that he has given X certificates, and that is why he is seeking.
And he wants that right to information now. Instruct your officers. If they have information, they have to furnish information. Why writ petition? Why petition? All this, etc. Unless it is Official Secrets Act, which you can hold abreast. The rest of the information should be distributed in the open market, which is the famous market in your place, Orissa. You can just distribute all that information. Right. The short grievance of the petitioner is as to non-consideration of his application by seeking certain information in relation to a particular employee who is working as a teacher in a particular school, which is aided. Is it aided school?
Well,
Aided school.
Aided school.
Yes. Aided school. First up. Next paragraph. Learned counsel for the petitioner argues that right to information having been legislated by the parliament, the authorities are bound to consider and furnish the information sought for. First off, This having not happened, this court should come to the aid of his client. First. Next paragraph. Learned AG on request accepting notice for the respondents, having resisted the petition for some time, now agrees to instruct the concerned officials to look into the grievance of the petitioner in a time-bound way and in accordance with law. First, this is appreciable. Next, in the above circumstances, petition is disposed of. Time for compliance is 4 weeks. 4 weeks. First of all, contentions of the parties are kept over. No words.
Item 6.
Yeah.
And order of termination from the post of assistant teacher is under challenge, Your Lordship.
Order of
Termination, Your Lordship.
termination.
My Lord.
How long you were working?
My Lord, working as assistant teacher, Your Lordship.
How long? How many years?
My Lord, since 1998, 26 years, Your Lordship.
26 years.
My Lord.
Why you are terminated?
My Lord, 2015, an inquiry was conducted on caste certificate of the petitioner, Your Lordship, after 17 years. And state level scrutiny committee recommended the district education officer to terminate the petitioner because he not belong to the scheduled caste, Your Lordship. That is findings, Your Lordship. Kindly see the page 22, Your Lordship. Sorry, Your Lordship. That is page 23, the operating person, Your Lordship. The district education officer Burger is directed to take necessary step to cancel the appointment of Sri Saroj Kumar Negi, so and so, who is now working as teacher in the village.
Because your caste certificate was not genuine.
My Lord, my certificate was that is on challenging the findings of the state level committee. I have filed a petition before this honorable court, Your Lordship, that this honorable court granted stay on the operation of that order, Your Lordship. This is the order, Your Lordship.
Then we will call this matter along with that petition.
Exactly.
Same judge or some other judge?
Both the matter are different, Your Lordship. This is one caste certificate matter and this is termination matter.
No, that's not it. I understand. Whether caste certificate matters also come before this court or go before some other court, procedural court. This court only.
It is consequential. Consequential order first.
Okay. Emergent notice. The AG is requested to accept notice for the respondent. First up. Call this matter week after next. Along with the WP.
WPC number 14958 of 2020.
Give that copy.
Yes, Your Lordship.
After 4 weeks. But in the meanwhile, objections, if any, what we call it, counter, if any, may be filed.
Item 7.
May I please, my lord?
Yes.
There is a batch of cases your lordship is hearing on survey of financial benefits under rule.
Issue emergent notice, AGA to accept notice for the respondents for this matter along with WP number. Sorry.
May I please, my lord? Observed about the nature of prayer that you are writing. May place a line of submission.
Yeah.
My lord, I have also mentioned that way. My lord, only the philosophy that I understand in India, we have a very, what should I say? It's a philosophical trait in India to express positive things by using negative words. Because your lordship would kindly appreciate it. We have concepts like non-violence, untouchability, non-cooperation, even in protest form. So that's from the philosophical trait that we have in this country to negative, positive ideas of substance. Even your lordship would kindly appreciate the fundamental rights guaranteed are also worded in negative, that there shall not be any discrimination. The state shall not discriminate. So that is the spirit with which it is written that everything in negative, but the intention is to express positive ideas of substance through negative wordings. That's what I understand as the.
That's all right. But the object of language is not to complicate the things.
No, it shouldn't be complicated. That point
it is to make things very simple. If you see Bhagavad Gita, so lucidly Lord Krishna counsels. Even in England, they have passed certain statutes repealing the Latin and Greek usage. Therefore, if it is simple,
My lord,
it becomes easy.
I definitely take that, but I just needed to explain why this tradition of writing is negative.
But that tradition is only in your High Court.
That's what.
I have gone to many other High Courts as a lawyer.
My lord.
Okay? Only in your High Court. It should be. There is one PC Moga. I wanted to tell this in my speech also. I have referred to BC Moga on pleadings, Wodgers on pleadings. Very simple things. When you make things simple, the mind becomes very happy to receive what you are saying. To understand what you have written, if I have to call Webster or NN
That
Martin,
is never called for. But I was just trying to address this issue
that if that was to be the reason, it should have been all over the country. That is not like that.
There
is a truth that also there is. But simple. Moga says, and there is a debate in Constituent Assembly as to what all writs we should enumerate in our Constitution. Dr. Ambedkar ji, Allaswamy, Krishnaswamy, Alladi Krishnaswamy Iyer, and B.N. Rao, Constitutional Advisor, they suggested we will not make it very cumbersome. We will say Indian High Courts and Supreme Court can issue writs in the nature of English law. Therefore, they did not use this one. And in some cases, Supreme Court granted relief, saying that the prayer column is not important to us. If we have understood what he wants, we can do that once. Therefore, make things very simple. It should be lucid. Should not be cumbersome. Already laws are cumbersome.
Yes, they are.
Laws are cumbersome because nobody can understand what the law is saying. Jeremy Bentham said, law shows its face. Your prayers also show what they are in mass.
They shouldn't be cumbersome, but I was just like
simple. Issue a writ of certiorari, quash it. So simple it is.
Item 8.
Yeah.
This is the petitioner is a life convict, my lord. He is coming because the state sentence board has rejected his petition for premature release, my lord. In the case, let's say, the board will sit on September 25, my lord. It is in this case, court has directed another accused to
convict.
Directed the government to, as per the order, my lord, that rejection order, if passed in this year, that accused will not taken for premature release consideration board for 2 years. For that, my lord, this petition was rejected in year 2021.
So
but
this is criminal motion.
That is come before me.
Yes,
it
my
is
lord.
not assigned.
It is
criminal jurisdiction is assigned to me.
It other matters. This is
comes in the residuary list.
Yes.
There is
rejection or challenge.
criminal law.
This order was challenged. No, my lord. The state sentence board or the order against this case was filed.
Right. But
Annexure 1.
No.
That is only state sentence board. That is not criminal, my lord. That is only the constitutional. That is the whether this petitioner will go further. It is also.
How many years of sentence he has served now?
He already has covered 19 years.
19 years. And life sentence means sentence to the entire life.
Entire life, man.
But
now
they provide for the early release.
Early release taken by the modern jail rules. This is functioning, and SOP of the NALSA guideline I have annexed Annexure 2, my lord.
You take notice and you say something.
My lord,
this is a case, lordship, already decided.
This case is considered, but he was found not suitable because of his bad conduct.
But my lord, the board will sit in the month of September 2025, 12th.
By that,
they will
2 years will be.
After 2 years, completed, my lord. Therefore, he will give you a chance to consideration.
Once in 2 years, you can apply. You just consider.
Government will give.
Post it before the board, and board will consider.
Yes, my lord. This is the order.
Allotment direct for reconsideration.
Petitioner, a convict serving sentence for an offense of murder under Article Section 302 of IPC 1860, is knocking at the doors of writ court, seeking a direction for his premature release.
But a national order, my lord. State sentence board should consider.
In terms of state policy. First of all. Next paragraph. Learned counsel for the petitioner submits that under the jail manual it is.
Yes, ma'am.
Under the extant jail manual in the state, there are provisions for parole, furlough, and premature release. Semicolon. A protocol is also in obtainment in that regard. Semicolon. Earlier application seeking premature release was negative, wide order dated 7/6/2022, and right to apply for release becomes coherent once a period of 2 years from the date of earlier order. Semicolon. She adds that in the month of September, the board, what is that board?
State Sentence Review Board.
State Sentence Review Board is meeting, and therefore a direction be issued to consider his representation for claimants. Kindly be seated. Vasantu. Should I call it as Mani or sister, younger sister? For younger sister, what is the word? No word.
बहन जैसे हिंदी में बोलते हैं भौनी.
Bhavani, okay. Next paragraph. Learned AGA on request appearing for the office resist the petition contending that once a person is tried and convicted for the punishable with life imprisonment, comma, it is for imprisonment for life. And therefore, no right of the kind would accrue to the petitioner who is convicted for the offense of murder and sentenced to undergo life imprisonment. First, having so stated, he agrees to instruct his client's officials to look into the grievance of the petitioner so that petitioner's request for early release is placed at the hands of the board when it is going to meet imminently. First off, with this proposal, petitioner, counsel for the petitioner is agreed. Next.
Government will send his name, my lord. Government will give a proposal before the board. The superintendent of
One sentence. Yeah, that is covered in this statement. In the above circumstances and with the above observations, petition is disposed of. Contentions are kept open for being considered at the hands of appropriate authority who would take a call in recommending case of the petitioner to the board for treatment at its hand. Okay. No cause.
Item 11.
Yes.
Really for antedate the date of regularization. In similar matter,
Notice. AGA for the OPs. Call this matter along with WP number. Yes.
Item 12.
12 also measure same.
12 also same.
My lord. In this case, we are appointed initially as sweeper.
Same.
Yeah.
Item 13.
Item 13, your lordship has already passed the similar order. This is the matter where but no interim, here in this case, granted the interim order. In this case, there is not required interim order, but I have filed an IA for dispensing with the certified copy of the judgment, because in that previous case, I have already filed, my lord. Therefore, the IA matter is there, my lord, for dispensing with the certified copy of annexures 3, my lord.
So only notice to be issued.
Yes, notice. I just want to pay one thing.
Notice.
Hello,
AGA to
opposite partner 1 to 5. State has to be issued accept notice. The writ petition is already available in the LMS service, my lord. That
is becomes easy. Otherwise, in that ground only matter will be pending here. That helps you.
And the notice issued to the opposite partner 6, the competent authority.
Notice to OP6. Yeah. Application seeking dispensation is favored. To be called along with this matter?
Yes, that can be. Because one judgment, 2 writ applications, my lord.
Item 14.
May I please? Yes.
It was just an open advertisement for Shiksha Sahak. His petitioner applied. She got selected, her name appeared in the merit list. But because of a wrong policy decision of the state government, keeping more than 50% as a reservation, so her name could not be found place, so she was not appointed. Now that faulty policy was challenged by several applications before the then tribunal. The tribunal upheld, saying that in consideration of the judgment by the Indra Sahani as well as M. Nagaraj case, so more than 50% cannot be allowed, hence it is ultra virus to the constitution. The state came in the writ petition before this Hon'Ble. Now the writ petition was dismissed. Thereafter, my lord, dismissed with a direction to again prepare a fresh merit list. They again prepared a fresh merit list. I was called upon to submit my documents. I submitted my document. And thereafter 2 years, my lord, on 2022, appointment order was issued. Now, my only limited query is that because of the no fault of the petitioner and for the fault of the state government, its policy, whatever it may be, I was allowed to suffer. Whereas, similarly, my lord, who came below 50% reservation, my lord, they were appointed by that time. So, I pray for notional benefit of my appointment. That is the limited prayer. Now, this case came before a coordinate bench of this Honorable Court, and it was decided, my lord. I have annexed under Annexation 9, saying that if the petitioner had not committed any fault, she cannot be deprived of her legitimate right of getting notional benefit for appointment. That is what page 9, your lordship may see the particular portion, my lord. Page, this is Annexation 9.
So, notional benefit means treated as having been appointed as on that day.
That is what. In 2002, they have issued appointment to some persons, my lord. But because they got 50%, I could not be elected. Now, page 25.
You have given a representation now.
I have given a representation showing that after this judgment, I have given
let them consider the representation.
The representation considering the judgment.
In the light of this judgment.
My lord.
In the light of this judgment.
Yes, my lord. That is.
Short grievance of the petitioner is as to non-consideration of his representation, her representation. Dated,
I given 2 representations. One, my lord, Annexure 10.
At Annexure 10 series.
Annexure 10 series. Just
dated
representation, my lord, Annexure 10.
23, 6, 20,
and Annexure 8, both.
23, 6, 20, 25 and
Annexure 8.
Date
Annexure 21, 2023.
20 January 2023,
16/4/2025.
16/4/2025, wherein
Annexure 8 and Annexure 8 and Annexure 10.
Annexure 8 and 10, wherein she has sought for grant of notional benefit of survey with the retrospective effect from the date other similarly circumstanced persons were appointed, comma, she having not been, comma, because the fault attributable to the state in wrongly prescribing percentage of reservation in employment in excess of the ceiling limit. First. Next paragraph. Learned counsel for the petitioner draws attention of the court to a coordinate bench decision in
Annexure 9.
WPC number 235 of which is that? Not that.
Annexure 9, madam. Annexure 9, relevant portion, page
1536 of 2022 between Indumati Rath versus State of Odisha and others, disposed of by the order dated 2/4/2025, saying that the subject representations need to be considered in the light of observations made. First off, this the said representations having remained unconsidered, comma, he is seeking the interference of this court. First off, kindly be seated. Learned,
my lord, my small prayer for his assistance. My lord, he has given representation to 3 persons. If you'll give to 1 person, then he can consider. Everybody's responsibility is no responsibility.
No, anyway, they should, whenever a representation is given, some high courts have taken the view that if he is not the competent authority, he should send it to competent authority who will take a decision.
My lord, let him give a representation to opposite party number 2 who can take a decision.
I think no. We'll direct 2 to consider that.
Yes.
That will the representation to be considered by 2.
By 2.
Learned AG preparing for the OPs, having initially resisted the petition, now graciously agrees to instruct OP number 2 to look into the grievance of the petitioner as has been aired in the subject representation, keeping in view the coordinate bench decision in a time-bound way. First, with this proposal, counsel for the petitioner is agreeable. First, next paragraph. In the above circumstances, petition is disposed of. Time for compliance is 8 weeks, which should include communication of the result of consideration to the petitioner. First off, it is open to solicit, etc., etc. No cause. Web copy to be acted upon. All orders of the copy to be acted upon. Yes.
And the stipulated period, time period.
Yeah, 8 weeks. Yes.
Yeah. Item 15. On behalf of Mr. Swine, I permitted to place below. On behalf of Mr. Swine, I permitted to place this matter.
Yes.
Grateful. Well, here is a matter, my lord. The present petition number 1, my lord, the being a power apartment holder, was applied for petition of building to the Bhubaneswar Municipal Corporation, my lord. They have deposited the money. Page 138, my lord, Annexure 4.
What's your prayer?
My prayer, because the passage is concerned, the other persons are get, my lord, the similar situated person, but my case, they have replied, they have denied, my lord. And now I have deposited the money. Bhubaneswar Municipal Commission says, my lord, corporation says, you have approached to the GA department. And I have wrote application to the GA department. GA department rejected my application.
Sorry. One sentence, pause. Another sentence, pause. Because pause is also very a lot of speech. Yes.
Then, my lord,
one
municipal.
Go by one by one. I'm not that fast, as fast as you are.
I'm sorry, my lord.
You want direction at the hands of this court.
Yes, ma'am.
What direction you want?
Lord, the passage is concerned. I have already the deposited money before the Bhubaneswar Municipal Corporation
For buying the passage.
Passage, my lord, the construction of residential building, my lord, on approval of the plan.
Approval of building plan.
Yes, my lord, there is a
That has not been approved.
No, my lord, they said stated your passage is not there because the adjacent to all the government lands, my lord. Now they have requested, my lord, they have wrote later me to approach before the GA department, General Administrative Department, my lord. GA department. Then, my lord, I have wrote a letter to the GA department. To my lord, whatever premium, I will give, my lord, ready to give the premium and allow to process, my lord. Now they have rejected my application on the ground, my lord. The OJLS Act Second Amendment Rule 2020 says there is no communication will be given. So there is a rule is provided. There is nothing has been provided.
What is that rule?
Yes.
What is your right to get government land?
Government. Now, lordship, for a moment, my lord, this. Now, my lord, secondary, my lord, the other persons
might have been wrongly given. A wrong does not give you right. Point is, which law gives you the right to take the government land by making payment? Which law?
My lord, the under OJLS Act. Sure. Now, my lord, for a moment, my lord, they have said the rule is concerned, but there is no such rule.
They may not be right.
My lord,
you show the law. Where your right arises.
My lord, they have only the consideration, Lord. There is no passage.
You have the right to consider representation.
Because, my lord,
you are not completely allowing me to argue also.
My lord, I'm grateful, Your Lordship.
It's a dialogue, actually. Otherwise, I keep quite like a rock of Gibraltar.
My lord.
Then pass order.
My lord.
How it will end?
No, this is not.
That's what you have to clarify. Hearing means, if you have patience.
My lord.
I should also have patience. Hearing means trying to understand each other. It's a transaction. Where you want particular benefit at the hands of this court. Therefore, you should convince it. If some doubts arise, you have to clarify them. Otherwise, doubts will be reflected in the order. That becomes a ground for appeal. But justice will not happen. Is it?
No.
I am asking you.
Yes, no.
You are before the High Court.
Yes.
We operate on the principle. No right, no writ.
No.
Where is your right?
My lord. As for the GA department plus the letter is concerned,
forget that letter. Show the law.
2020.
Show the law to me.
So, Lordship, for a moment, my lord. Lordship, for a moment. Lordship, for a moment. It's a rule, my lord. I would have actually to listen.
Which rule? Take it. Yes. This is the rule.
This is the notification.
No,
the 2000 amendment notification.
These rules are made under which act?
The Odisha government land settlement rule, my lords.
These rules are made under which?
Settlement Act? Yes, my lord. Settlement Act and Rule 83.
And which rule gives you the right?
Subsequently, my lord, the lordship this page, lordship this notification only, my lord. This notification.
This one
only. This notification.
Which rule?
From lords, the second page, my lord, the third page, my lord. The H in clause 15. So, lordship. So I'm sorry, my lord. The page 4, my lord. That designate not the lordship. The page 4. The 3. The said rule in schedule VI. My lord, the C. For clause 3 of following clauses shall be substituted mainly 3.
Where is the substantive rule? This is amendment.
Amended rule, my lord.
Which is the substantive rule?
Substantive rule, my lord. That should make only for a moment. Clause 3. Let's be positive, my lord.
It appears there is some rule which provides for
Passage
land.
That's why I issue notice so that I can come out.
Issue emergent notice. You appear for which all office?
No, one.
Mr. G appears for OP number 1. Emergent notice to other OPs.
One and two
both. It is open to petitioner in addition to taking individual steps to serve copy of the petition on the panel advocates if any who represent OPs 1 and 2. Yes. For this matter after service. Yes.
Item 16. Item 16. Yes, may I please, my lords? In item number 16,
Sir.
it is a matter regarding the corruption and irregularities in the Anganwadi center.
And
Irregularities.
Irregularity.
Yes. And a joint inquiry has been done. And it is found that there are several irregularity.
Who are you?
My lords,
Who are you?
I am the villager and my children from my family are also living there. In Anganwadi center.
Public interest.
No, my lord.
Is this a public interest litigation?
No, already a job. No, my lord. My children of my family is reading there in Anganwadi center. And joint inquiry have found that irregularity is there. Like non-formation of Matru committee, the mother committee, inspection committee, Gramya committee, missing of important records, absence in VHND and immunization program,
All right.
misappropriation of money.
These irregularities are.
Annexure 1 series, yes.
Then what they should have done?
They should have take action against the Anganwadi center, but they have done.
You take notice and just tell us what to. Can anybody help gentleman? Yeah. Brother G,
My lord.
you can instruct your
I'll take that.
officials to
Yes.
look into the grievance of the petitioner. You have given the representation.
My lord, Annexure 1 series, they have the report. They have shown.
I'm asking.
Yes, I have given the representation and villagers also given the representation. Annexure 3 series.
Right. Kindly be seated. How many petitioners?
One petition.
Petitioner is knocking at the doors of writ courts, grieving against non-consideration of his representation, and also villagers' representation for taking action in terms of inquiry report that found certain illegalities or irregularities in the, where it is? In the
Chandrapada.
Mohu Bazar Dandi. Mohu Bazar Dandi.
right.
Anganwadi center in
Anganwadi
Ali
center.
PS. Kendrapada.
At side. So,
Mohu Bazar Dandi.
First off. Learned counsel for the petitioner submits that his children also study in the said Anganwadi institution, and therefore he is genuinely interested in cleansing the system, at least in terms of recommendations made in the inquiry report. First off, the representations have not met their consideration. Kindly be seated, Mr. G. Met their consideration at the hands of powers that be. And therefore, this court should intervene in the matter. Next one. Learned AGA, on request, having accepted notice for the OPs, opposes the petition, contending that it is in the nature of social action litigation, and therefore petitioner should be relegated to PIL court. First, having so contended, now he fairly agrees with the suggestion of this court that he should instruct the official OPs to look into the grievance of the petitioner in accordance with law and in a time-bound way. First, he requests the court to keep all contentions of the parties to be kept open. First, with this, the counsel for the petitioner is agreeable. First, next paragraph. In the above circumstances, petition is disposed of, fixing a period of 8 weeks for granting redressal to the subject representations and to inform result of such consideration to the petitioner. First, all contentions are kept open. No course. It is open to solicit, etc. No course.
Lordship, particularly opposite part number 3.
They will look into all of them.
And one thing is children of my family, not my children of my family.
Children of your family, not your children.
No, my family, my
You can say children of his family, something like that. What is meant to be. Their father, mother are keeping quiet and you are more concerned about it. Anyway. Yes.
Item 17.
A petition is a class for employee seeking modification of his regulation order from the date of the initial engagement.
Similar matters we have seen. Similar take that issue urgent notice. Yes, please.
18 also
would be accepts notice for 18 also same.
Yes,
same.
Item 19.
May I please, Your Lordship. Your Lordship, the petitioner is challenging the rejection order passed by the opposite parties, wherein the prayer of the petitioner for the grant of the benefit of RACP has been rejected, Your Lordship.
They have issued notice in similar matters.
Yes, Your Lordship.
AGA to accept notice. Call this matter along with WP number.
No, Your Lordship.
That was before division bench and now in the last week of September. Okay.
Third week of September.
Huh? Third week of September. Okay.
Last one is also similar matter.
21. Yes.
Oblige, Your Lordship.
Call along with each other.
Item 22.
22. 20 you have left over. Urgent.
20 urgent.
Okay.
Urgent.
Item 22.
Yes, sir. Yes, sir.
The petitioner is a representative.
Keep that mic. Yeah.
Working as a demonstrator.
Your client is working as a demonstrator.
Yeah, but the general governing body has proposed for the promotional post of the petitioner. Accordingly, the petitioner has ventilated his grievance by filing the representation. That is Annex 3, Lordship. But the authority to take any action pursuant to the representation.
For grant of promotion.
Grant of promotion.
Whether there is recommendation for promotion.
Plus.
Who has recommended?
The governing body. That is Annex 1.
Has recommended.
Lordship. In Annex 1.
In terms of that, who should take the governing body recommendation dated?
That Lordship. That is 14/9/2023. Annex 1.
Your representation dated?
That Lordship 12/8/2024. Annex 3.
Who should take the decision?
The government Lordship, the OP1.
OP1? You look into that. Okay. Right on. Kindly be seated. Sit down, sit down. Please knocking at the doors of report with the following prayers. Next paragraph. Learned counsel for the petitioner submits that the governing council of the institution in question, wide resolution dated 14/9/2023, a copy whereof avails at Annexure 1, has a recommended case of his client for promotion from the post of demonstrator to
lecturer biology.
To that of lecturer, brackets biology,
Sorry. In biology, to lecturer in botany.
Botany. Botany is also part of biology. Botany. Semicolon. In terms of said resolution, his client has already submitted a representation dated 12/8/2024, a copy whereof avails at Annexure 2. And though more than a year has lapsed, no decision is taken by one, which is bound to take a decision on a normative basis. First up. Next paragraph. Learned AGA, Mr. Mohanty, on request accepting notice for the respondent, having resisted the petition for some time on the ground that right to promotion does not avail, although right to consideration of candidature for promotion may avail, agrees to instruct his official of OPs to look into the grievance of the petitioner in accordance with law and in a time bound. First up, with this proposal, counsel for the petitioner is agreeable. Next paragraph. In the above circumstances, petition is disposed of. First up, decision to be taken on the subject representation in the light of the governing council resolution within an outer limit of 8 weeks, which would include communication time for communicating the decision taken to the petitioner. First of all, contentions are kept open. Open to solicit. No course. Okay. Item 23. Yes, sir.
Here I have challenged the Annexure 14. That is the inquiry report, and there I have been asked to file show cause to the inquiry report. I have challenged that report on the ground that in fact there is no inquiry at all. Because your lordship will get it. It is very much available. Your lordship may turn to page 45, Annexure 11. Now, when the proceeding was stayed by this honorable court on the ground that no documents were supplied to him to file the statement of defense, the expert inquiry was conducted and the report was submitted. That is a lot will get at page 45 and the report is page 46. That report was submitted on 17/4/24. Page 48.
Where have you held the inquiry?
Milord, so far this inquiry report is concerned. At page 47 also.
Correct.
During the course of inquiry, the delinquent teacher Singh was asked to say about his fake certificate in the BD examination or to submit this.
Where is the inquiry held? Inquiry should be held with the participation of the officer because
but this same
major charge.
But they have submitted.
You want to spoil your case?
Sir.
Yes.
I'm sorry.
If inquiry is a report, you can't hold inquiry keeping the employee in darkness and say you file representation to the report. That is not Muhammad Ramjan Khan. What is that? 91 Supreme Court.
Ramjan Khan.
That's not the object.
91 Supreme.
Object is you should hold the inquiry with the participation of the delinquent.
And fair opportunity should be.
Then report copy to be furnished to him. You should have his say.
May take the instruction on this ground.
Issue emergent notice. Call this matter. Let the AGA accepts notice for the OPs. Call this matter next week.
Till then, my lord, no. Because my lord, you have a glance.
Let us see. Nothing will happen. If it is there, yes. If there is something wrong happens, we will set it right. Okay. If your version is true.
Yes.
Yep.
Next week, my lord, I'll pick up.
Next week it will come one day this side, that side. Item 24.
The connected matter.
24 is connected.
Two matters are there.
Two matters are there. In 23, two.
Same order. Yes.
May I please? When this petitioner was an applicant for the post in accordance to advertisement annexure of 2, my lord. Running page 28. Subsequently, the eligibility list was published. Annexure running page 42. My name is not there. So there is no region also not indicated therein. Earlier, I was in that college, thereafter it converted into university, working there from 2009 to 2012. According to that, in my place, another one was posted. So I have come to the Honorable Court. The Honorable Court has passed the order. When vacancy will arise, then I will be adjusted there. Running page 27, running page 52 and 53 is the operating part of this Honorable Court's order matter. In Petition 453 in 2013, I have come to the Honorable Court, and the Honorable Court had directed to July 2013 that operating part of that order on taking a holistic views of the matter. We are of the considered opinion that the advertisement is so and so issued by the opposite partner to publish in the
considered.
No.
Your case should be considered.
But not
whether have they appointed anybody?
My lord, they are now in accordance to advertisement. I am the BR for the faculty member for BR. Annexure page 29.
You see, India has to answer the charge. No?
We have been added as OP number 2 and 3.
You are OP1.
I am OP1.
Yes. Notice. EGA for OP1. Emergent notice. Any standing counsel?
No, my lord.
No. OP is 2 and 3. Returnable within 3 weeks.
The seat and change.
Let us see.
Item 25.
It's within 3 weeks. Okay.
Item 25. May I please receive?
Yes, sir.
My lord, this matter regarding cancellation of my allotment of house and eviction, my lord. In which house I am residing for.
On the ground that you are owning one of you false affidavit, etc.
My lord.
Issue emergent notice. Identity model as paid for. We can say status quo to be maintained. Issue emergent notice. BDA for?
There, my lord, BDA is party.
You are not
Bhubaneswar Development Authority.
Issue emergent notice.
Their panel of law.
In order of status quo till next date of hearing. First of requisites within 3 days. Okay.
Item 26.
My lord, matter is related pension as per the pensionary benefit rules.
Pension has not been released to you.
Block grant pension on the 30th of September. Block grant pension, claim for block grant pension.
Hemant Kumar, covered by Hemant Kumar Chotra.
Division bench. This is posted to the division bench. My lord, so hard in part. So now it is 3rd week of September. It was posted to 18th.
15. Anyway, you take notice.
Yes, ma'am.
Afterwards, whatever happens there, it can be applied here.
Yes.
ASC to accept notice correspondence. Call this matter in the 2nd week of October. Yes.
My lord, same. Item number 27 is.
27 also same?
Yes.
Call along with each other. Yes.
Item 28.
I'm on behalf of yes, the matter is relating to disbursement of RACP benefit.
RACP issue notice, call along with WP number. Accepts notice correspondence. Give that WP, which is that WP?
WPC number 19956 of 2025.
19956 of
2025.
Next.
Item 29.
Passover. Just turn the pages. I may come to your aid. Turn the page. What is that matter about?
Challenging the annexure 10, my lord. Gradation list.
Gradation list you are challenging.
My lord.
But is the
appointment of the junior teacher, my lord.
Appointment of the junior teacher pursuant to the advertisement dated 10/9/2023. Kindly see number 10.
So the horizontal reservation is not considered.
My lord. Annex 10 on 63.
What's your name?
Niranjan Jena, my lord.
Heard Sri Niranjan Jena. First up, issue emergent notice. OPs, all OPs, ASC, accept notice for OPs. Okay. Next.
Item 30. I have paid for arrear family pension from 30th November 2022 to 1/1/2024 for about 12 months.
12
For which
20.
annexure 3 is pending, ma'am, before OP number 2.
OP number 2 to consider the annexure.
Yes, ma'am.
The short grievance of the petitioner is as to alleged non-payment of arrears of family pension for the period between 30/11/2022 and 1/1/2024, despite giving representation. First up. Next paragraph. Learned AGA graciously appearing for the OPs graciously agrees with the suggestion of this court to instruct his clients to look into the grievance of the petitioner as has been aired in the representation in 2025, a copy whereof avails at Annexure 3 in accordance with law and in a time-bound manner. First, with this proposal, counsel for the petitioner is agreeable. Next paragraph. In the above circumstances, petition is disposed of, fixing a period of 6 weeks for consideration of the representation. And in the 7th week, the result of consideration to be informed to the petitioner. First of all contention opens. It is open to solicit information. No cause.
Item 31.
The person has prayed to grant representation in this regard. Earlier order in past.
Similar matters are repeated. Issue emergent notice. ASC for respondent. Have you given this same order? We can make this.
Yes, please.
That's separate order.
33 also same. That's good.
30?
33 next.
33 also same.
Same. That's good.
They're
Same.
identical.
Same.
33 also. Okay.
May I please, Your Lordship?
Yes.
The petitioner prayed for the Supreme Court to change the surname and father's name and mother's name from the documents school certificate. Reason being, there is a suit which has been filed by the petitioner declaring that he is the son of opposite party number 5, Your Lordship. The fact of the case is that the mother of the petitioner married second time to opposite party number 4, Your Lordship. And he begotten from opposite party number 4. During stay in the matrimonial home, there is a dispute between mother and father. For that reason, she drove out from the matrimonial home and she stayed in.
You made any representation?
Yes, Your Lordship. The school has been written to the Board of Secondary Education to correct the name and surname and the father's name and mother's name to the opposite. That is annexure 3. Your
Pradhan, it should be Nayak.
Nayak, Your Lordship. And father's name, it should be father's name also can be changed.
But for board, you appear, Mr.
No, my lord, we are not happy.
Then let notice go.
I will serve a copy to Mr. Rao, who is SS Rao, senior advocate.
Issue emergent notice. Yeah, OP ASC appears for 1.
Yes, sir.
ASC accept notice for number 1, OP 1. Mr. Rao, senior counsel.
SS Rao, senior advocate.
SS Rao, senior advocate.
Senior advocate.
But we can't issue notice to senior advocate, no? Any advocate on record is there?
His associates is there.
Tell them. We don't know the issue, emergent notice to the second respondent. Only two respondents. Okay. Returnable within 2 weeks.
Vikram Mahanti, Your Lordship, I will. Vikram Mahanti.
Shri Vikram Mahanti, Project Panel Council is requested to accept notice for respondent number 2, OP number 2. All next 34. Which is your matter?
42, sir.
42. You kindly be seated. I'll call you.
34, my lord.
Lordship, a date may be fixed for.
Call after 2 weeks.
My lord, 34. The petitioner is working as junior librarian in a government MPC Autonomous College, Baripada, my lord. Petitioner is working as junior librarian, my lord.
I'll return within 5 minutes.
Yes, my lord, obliged.
I will wait and return within 5 minutes. Yes, brother, just
Working as junior librarian, my lord.
coming.
Help
To
you.
others.
My lord. I have my grievances at Annexure 8, my lord.
Annexure 8 representation is not considered.
Not considered. The president dated 28-24, my lord.
You consider that
Yes, my lord. In the light of the Annexure 6, my lord.
in the light of Annexure 6,
My lord.
that government order it is, notification.
My lord.
You are working as
Junior librarian, my lord.
petitioner. We have been working as a junior librarian in OP number.
University, MPC Autonomous College, my lord.
In government college.
My lord.
In which college?
MPC Autonomous College, my lord.
You have not made it a party.
That is not my lord.
In MPC government so college. He is against non-consideration of his representation dated
2024.
20 August 2024 at Annexure 8,
My lord.
wherein he has sought for extension of financial benefits as per higher education notification dated 3/4/2023 at Annexure
6.
6. First one. Counsel for the petitioner submits that although similarly personnel have been granted the extension of such benefits, it is only in the case of his client a stepmotherly attitude is shown. First one. Therefore, he submits, this court should come to the aid of poor petitioner. Next one. Learned DAC appearing for the OPs on request fairly agrees to instruct his jurisdictional OPs to look into the grievance of the petitioner in accordance with law, more particularly in the light of the subject notification within a time-bound manner. First off, he tells the court to keep all contentions open. First off, with this proposal, counsel for the petitioner is agreeable. You are agreeable with that point, okay? All right. Next one, in the above circumstances, petition is disposed of 8 weeks. Open to solicit.
Obliged.
No course. Yes.
Item 35.
Well, here the petitioner's grievance is that the project, my lords, namely innovation work of a Ma Mangala temple in a Gram Panchayat, in Dochia Gram Panchayat, that was sanctioned by the government.
There is a temple.
There is a temple and it's
particular village.
In a particular village, namely Dochia Gram Panchayat in district Puri, my lords.
Puri.
And that project and including various other projects were sanctioned by the government under the CM Special Assistance Scheme, my lord. That is that was earlier named as Special Problem Fund (SPF). That was changed to CM Special Assistance Mukhyamantri Swatantra Sayata from the year 2023-24. While it was in process, my lord, it was recently sanctioned in December 2023. I've annexed that in the. While it was in process, my lord, the government now in May issued a general guideline to all the collectors that since 1997, all the outdated projects and projects that were sanctioned under that scheme, CM Special Assistance, my lord, I'm the petitioner of that village, my lord, of a Gramya committee. Is a secretary, my lords.
Secretary.
My lords. My lords, what happened is that.
The nature of PIL.
My lord, it is only for that temple purpose only, limited to that. So no
temple
public
is not your property.
Public is not involved.
Not involved. It's only your temple.
No, my lord. For the village, my lord. For the village, my lord.
It belongs to everybody.
My lord. For
village.
My lord.
There is one famous statement. Do you know? It is ascribed to Hugo Crucius. Of course, Aristotle also. That belongs to none belongs to all. That belongs to all belongs to none. Sun, moon, etc. They belong to everybody. Therefore, you cannot claim that I am the exclusive owner of this sun. Similarly, temple belongs to everybody. It's a public institution where people gather, pray. Is it? So therefore, go before PIL.
No, the representative has filed this.
So representation to be considered. This court is famous for issuance of orders for consideration of representation.
I won't say that one of the.
And issuance of multiple notice in contempt matters. Multiple orders. First contempt, second contempt, third contempt.
They have, my lords.
What do you say?
It at all is not maintainable.
That I told him actually. I told him not maintainable in Dixit's court. It is maintainable in PIL.
Your Lordship, kindly see Annexure 2, page 18.
Now, have you given any representation?
Yes. Not objection given under Annexure 7.
That we will treat as representation. You take a call on that.
Yes.
All right.
Yes.
Only if I may pray, my lords, the project now has.
Prayer, you should do it in temple.
Lords, this is also a temple, my lords.
Temple of Justice.
Temple of Justice.
We are only a pujari.
That project has been now only on a recommendation of an MLA. It has been
in the renovation of Ma Mangal Temple, Devi Temple.
Ma Mangala Temple.
Ma Mangala Temple.
That has
Puri. In keeping within a particular temple. They should, you have made the representation, no? Objections you have filed.
Objections.
Objections, why? To what objections? To the repairs?
My lord, to the collector, they have made the objection, but now, my lords, the collector has moved to the government and government has approved the diversion of the project to other areas and other projects. So that fund will be, my lord, diverted to other areas if...
other temples.
My lord, other projects, my lord, that has been diverted.
Projects mean?
In that Annexure 6, page 38, if you lost my kindly see.
No, I'm asking you.
Projects means this particular project for which the amount was sanctioned, rupees 50 lakhs.
They are not supposed to divert it to other...
That is my grievance, but they have diverted it to other 5 projects. So
just look into that.
Your Lordship, kindly see Annexure 2. That projects sanctioned under Chief Minister Mukhyamantri Sahayata Yojana since inception of scheme 97, 98 to 23 and 24, but not started regarding. You did that is not the only temple matter. There are so many projects. Your Lordship, kindly see Annexure 3.
No, but if you allocate particular budget for particular purpose, diversion is not that easy.
No, it is from 97 and 98. All this now it is being diverted because it was sanctioned in the year 1998 to 2023. Now,
but this has been
the government has never taken up that project.
But this has been sanctioned recently only in December 2020. It was in process and Bhumi Pujan was also done and area was also earmarked for the project, and now this has also been included in that list. My grievance is that this project also has been included in that list.
Total 273 projects.
Correct. The projects are there. The project work should be accomplished.
My lord.
If it is accomplished only on paper, where the money will go? Money will go elsewhere.
Budgetary provisions are made,
Budgetary
but
provisions are made.
could not be established.
No,
Long since.
no, that is no answer. If you have allocated budget funds for a project, it is your duty to ensure that projects are accomplished, completed by using that fund. If that has not happened, the voter is entitled to ask, you have allocated so much money for this project. What have you done? That is his case. Though the best question is to ask the concerned local representative who represents that constituency. But still, court cannot turn its Nelson's eye.
You
consider.
They have approved the collector, let collector.
You make the collector
Fresh representation.
airing your grievance,
My lords.
saying that the project in question has not been accomplished and the amount is being diverted to other projects.
My lords.
All right.
My lords, it has been diverted on the basis of a MLA.
You make the representation, whatever you want to say.
My lords.
Where you have found objections.
My lords.
Now that has crossed.
That has crossed. That
Crossed now.
development has occurred.
That should happen.
My lord.
You make a
So
representation.
may I make a representation to, my lord, the Planning and Convergence Department, because the government has approved for diversion. No, I need to make a representation before OP2, my lords.
OP number 2.
My lords.
Because petition has the following prayer. First, learned counsel appearing for the petitioner, having argued the matter for some time, agrees with the suggestion of this court, which is suggestion of learned AGA also, that he should make an appropriate representation to OP number 2, airing his grievance, so that the said grievance would be granted redressal by OP number 2 in a time-bound way and in accordance with law. First term. Next paragraph. In view of the above, petition is disposed of. Time for making the representation is 2 weeks. Semicolon. If one is made, the same shall be considered in accordance with law, and result of such consideration shall be communicated to the petitioner within an outer limit of 6 weeks. First, all contentions of the parties are kept out. It is open to solicit information.
May pray if, till consideration the annexes may be.
Nothing will. Nothing like that. The first case itself is weak. I do not want to.
My lords, I'm
empty-handed because you have argued so well. Yes.
My lords.
Item 36.
May I please, lords?
Yeah.
Well, this matter relates to regularization of service.
Yes.
Well, the petitioners have put in more than 12 years of service as part-time instructor in physical education. Lordship may kindly turn to Annexure 1. After facing due process of selection, there was engagement under Annexure 1. They participated in the selection process. Thereafter, they were engaged by virtue of a common order, that is on 22/10/2013 under Annexure 2. And they have already put in more than 12 years of service. And they are getting paltry amount of rupees 10,000 per month. And my case is squarely covered by the judgment in Jago's case. So Lordship may kindly see that.
Will issue notice that will come out with their.
May I suggest one thing?
Consider.
Let the representatives consider in the light of this judgment.
Part-time.
No, part-time. That has been dealt with. That has been dealt with in Jago's case.
Part-time is also one paragraph.
Yes, yes. Your Lordship may kindly see paragraph 12.
Jago in Jago.
No.
Shripad case, that is
no, Jago.
Contraction.
No, Jago. Your Lordship may kindly see para 12.
In fact, both the judgments I have considered in one matter.
Yes.
In relating to some electricity company or something like that.
Yes. Swearage board case. Yes.
this judgment, you consider the representation and all contentions will keep open.
एक केस है नहीं मो जो थे consider person
How many petitioners?
There are 18 petitioners. By virtue of a common appointment order, they were engaged.
They are all part-timers.
Part-time physical instructors. They are getting 10,000 rupees per month.
18 part-time instructors.
Physical education instructors.
Physical education instructors are knocking at the doors of writ court, seeking a direction for the regularization of their services on the ground that they have completed about 12 years of blemished service and that there is requirement of their services on regular basis in the institutions wherein they have been posted. First, learned counsel for the petitioner presses into service apex court decision in Chago in support of his contention. First, next paragraph. Learned AGA on request accepting notice for the respondents opposes the petition, inter alia contending that all the petitioners are only part-timers and therefore ordinarily they will not have right to regularization of their services on par with full-timers. First, having so contended, now he fairly agrees to instruct the clients to look into the grievance of the petitioner, as has been aired in the representation dated
21/4/2025.
21/4/2025, a copy whereof avails
Annexure 4.
Annexure 4.
To the opposite party number 2.
That has been addressed to OP number 2.
State Project Director.
Namely, the State Project Director.
Yes.
First. With this proposal, counsel for the petitioners is agreeable. You are agreeable with that?
Yes.
Next paragraph. In the above circumstances, petition is disposed of, fixing a period of 8 weeks for consideration of the subject representation and to inform the petitioners individually the result of such consideration within an outer limit of 9 weeks. First, all contentions are kept open. First, it hardly needs to be stated that the consideration should happen in the light of observations of the apex court in Chago.
Yes.
And such other norms. First, open to solicit. No force.
The connected matter is also same.
Which one?
My lord,
both are same.
Both are same. Here 8 petitioners. And representation date is different. 21/3/2025.
Petitions. That is both people common now.
Next.
Item 37.
But this is a case. The petitioner is a regular graduate teacher. His appointment has been approved and he is receiving block grant. My lord, he was falsely implicated in a criminal case. Allegation was made against him that he misbehaved a class 9 student, class 9 girl student of that school, for which FIR was lodged against her. FIR was lodged against the petitioner. He was taken to custody. He remained in custody for more than 48 hours. And thereafter he was enlarged on bail. I have got the order. My lord, my disciplinary authority is the management. As per Rule 21 of the 1974 rules, managing committee is my disciplinary authority. The district education officer has no jurisdiction to direct the managing committee to remove me from service. Your Lordship may kindly turn to Annexure 4 at page 14. Aided institution. 74 rules is applicable. Under the 74 rules, Your Lordship may kindly see Rule 21. Read. 21. My Lord, page 900. Page 992.
Kindly read.
Disciplinary authorities, 21(1). The director may impose any of the penalties specified in Rule 20 on any employee, provided that the director shall not initiate any disciplinary proceeding unless the managing committee or the governing case may be refuses or neglects to take disciplinary action against any employee. If the managing committee refuses to take disciplinary action against any employee, then the director may initiate.
In this case, there is no refusal.
No refusal. No refusal.
Have you taken any decision?
No, my lord. Your lordship may kindly sit. Let me complete. My lord, the district education officer Denkanar, who has passed the order under Annexure 4, my first submission before your lordship is he has no jurisdiction in the matter. Because he has said, and this order has been issued with a premeditation to remove the petitioner from service. Your lordship may kindly see that. And my lord, where an order has been issued with a premeditation, as per the judgment of the Honorable Apex Court in Siemens case, my lord, that will not be treated as a premature order, and that order is required is to be interfered with.
Any inquiry is held in the matter?
No inquiry has been held.
Then inquiry has to be held.
But there is no...
The incident happened few days back.
Yes, few days back.
Even
I am agreed by this letter. Let me complete. But I am agreed by this order. Who is the district education officer to write such a letter that to directing the managing committee to remove him from service?
But the allegation is very wide.
Well, allegation is, my lord, I misbehaved. That is the allegation. And because of personal animosity, such allegation has been made.
One more.
The allegation has not yet been proved.
No, till proof happens, you cannot be in the classroom.
Yes.
What about the other children?
Well, that is the allegation.
Other children.
Well, that is the allegation.
Always allegations only.
And so far as government rules is concerned, under Rule 12 CA rules, if a government employee remains in custody for more than 48 hours, he is deemed to be under suspension. But here, the district education officer who has no jurisdiction and who has no authority in the matter, he is allowed to submit.
By following due procedure of law.
No. That order is there. You may kindly see the second paragraph.
Anyway, you are under deemed suspension.
Yes. Well, as per the government rules, but so far as aided institutions are concerned, that rule is not applicable. There is a judgment of this Honorable Court.
But still, I will not interfere in this matter. I will write some bad order. You may suffer. Instead, you think what you want to do. Because allegation.
My submission is,
I cannot permit your client to go and stand in front of the students. What about the parents? How anxiety the parents will have? You can we can say, hold inquiry immediately and complete it. Well, a question of relief to such people. In a sense, I am not saying anything. No, I am only.
But this is mere allegation. This is mere allegation.
Based upon this.
This is mere allegation. So, kindly see, if any allegation is made, maybe it false, or may it be correct.
Let them hold. Anyway, you cannot stand in front of the student.
But my submission is
because parents will be apprehensive. Can you see? You just imagine that you are the parent. I am the parent of that child.
Well, rule of law will not.
Rule of law is all right. We are not going to hang you now to the nearest tree. You are asking you to go undergo the inquiry. That's all.
Yes, I am ready. I am ready to face inquiry.
Completed.
I am ready to face inquiry. My lord, I am not running away. My lord, my submission before your lordships is, my lord, who is the district education officer directing the management?
Direct the management to hold the inquiry.
Yes, your lordship. Direct the management to conduct an inquiry.
Till to be outside the campus.
He must have been postcard, must have been imposed on him. Postcard.
Postcard.
Anyway, you take what he says. Who is the authority? Let that authority take the content. This one. But some other officer not concerned, some Gram Panchayat employee cannot direct any action against.
This is district education officer.
No,
Who is he? Who is he?
He is the authority.
No. Show me the law.
He is the authority granting aid.
Who else will direct? Who else will direct? The management, when the management is silent, who will take care of the FOCSO Act is his committing office.
You take notice.
Yes.
By objections, so that next date we will treat this matter.
Yes.
Issue notice. Learned AGA on request accepts notice for the which office?
Lord.
You have made the school also party, school management?
Yes. OP number 4, I will take notice by speed post.
State 1, 2, 3.
1, 2, 3, my learned friend will.
Emergent notice to OP number 4. No case is made out for order. Okay. Next.
Item 30.
Call after 4 weeks.
Correct.
Item 30.
Interim order, no coercive action may be taken.
No. No interim order. No case is made out for interim order regarding had to wideness of the allegations made against the petition. Okay.
Well, may I suggest one thing?
Yes.
Well, let the interim application lie over.
The last line you can do.
Sir.
Yeah.
38, I have given the similar order, my lord, have already passed. In case of transfer.
39.
38, my lord.
38.
I have given the corrected copy, my lord.
You have given AGM. You have corrected it.
My lord. Subject.
Yes.
Item 39.
May I please?
There is one provision under CPC, Order 14 rule, I don't know, which provides for filing of draft issues. The days may come when lawyers may be asked to file draft judgments also. Yes.
May please. You are the petitioner, my lord. Working as a reader in statistics and working in an aided institution.
Working as?
Reader in statistics, my lord, in an aided institution. Challenging the order of the transfer issued by the OP number 2 on my lord, Annex 5, whereby the petition has been transferred with less than 9 months left in our service career, my lord. And the government circular says
within 1 year.
Within 2 years.
2 years.
Our circular says Annex 6 series, page 38.
Who appears for the OP?
State, only state.
Remaining only 9 months.
9 months.
Why you want to trouble? Have you given representation to retain you there only?
Representation I have not given, my lord.
You give representation, they will consider that representation. Till that consideration happens, permit you to remain in the same place.
No, my lord.
All right. The short grievance of the petitioner is as to the transfer.
Order dated 35.
Order dated
31st July 2025.
31/7/2025. A copy whereof avails at Annex 5. First off. Sit down. Learned counsel for the petitioner, invoking the provisions of transfer guidelines, TG, submits that his client has got a short stint of service of 9 months, lay down the office, and therefore he could not have been unceremoniously transferred to some other place. First. Next paragraph. Learned AGA, on request appearing for the office, opposes the petition, saying that the transfer guidelines are only pure and simple executive instructions, and therefore, even if there is violation of the guidelines, no coherent cause of action arises to approach the court. First off. having so contended, now he agrees with the suggestion of this court that petitioner should give a representation to the concerned authorities, and that till such the consideration of such a representation happens, the immune transfer order should be kept in a suspended animation.
Insofar as the petitioner is concerned.
So far as petitioner is. First, with this proposal, petitioner is also, counsel for the petitioner is also agreed. Next paragraph. In the above circumstances, petition is disposed of. Petitioner to make the representation within 1 week, reckon from this day, semicolon. Till consideration of the representation happens, petitioner shall not be displaced from the present place. First, all contentions are kept open. No cause.
Well, instead of directing to Annexure 5, till then Annexure 5 may not be given effect.
Who have said that? You will not be displaced.
Displaced, they may interpret, but they have already relieved my since 2nd August.
First, if already displaced, he shall be called back to continue in the very same school.
They have not joined, but same college, same school, same college.
Same college. College. Okay.
Item 40. May I please tell us? The petitioner at Annexure 1, he was he is continuing in the post of accountant cum support staff.
You have drafted your prayer very good. I should appreciate that. Prayer is very short.
Published. Here the same issue has already
disclosed to petitioner number 2 in clause 6.
My lord.
Adarsha Vidyalaya.
Here the difference is that I was before this before my lords on previous occasions. Well, my lord, may kindly have a glance at page Annexure 6. That is the first time I came before my lords where this order was passed. That is at Annexure page 32.
32.
My lord.
Justice Satpathe's order.
My lord. Here, my lord, the opposite party was direct dispose of my grievances. It was directed, I will approach by 7th, and the opposite party was directed to dispose of my grievance by 10th, because 10th was the last day of 10th. Date of document verification was 10th, my lord. This was not carried out by the opposite parties. I filed one contempt. That was not listed, my lord. In the meantime, I received this annexure. The next annexure, 7/4/2025, page 34, this RTI series, my lord. Where what they have said, my lord may directly have a glance at page.
This admission is given or not given?
No, my lord. This is relating to another school where this RTI application says that the person who is continuing in the same post as that of the petitioner, his son has been given. That is at page 39, my lord.
So others they have given.
My lord, in other school, the same the post.
Any vacancies are available?
My lord, there is one vacancy.
Where?
In the same school, my lord.
Just look into the question of admission. DG is requested to accept emergent notice. Post this matter on Monday.
My lord. Yes.
Okay. Person. Since urgency is involved in view of cut-off date for admission to school being fast approaching. You copy. You just speak to concerned officer, get admission. You, in the event he gets admission, take best paid up, offer it to government and okay. To other friends also.
Deeply.
Item 41. In this case, my lord, IA number 12233. I have prayed for this salary. My lord, in spite of the fact they have not filed counter or not replied to the miscase, and OUAT has given the budget, and I am working, and in spite of this interim order, they are not paying the salary.
Is there interim order to pay salary?
No, interim order to continue. that I am continuing as senior research fellow.
He is continuing.
My lord,
He is asking a question. Answer the question. Is he continuing?
my lord, that instruction I don't have, man.
When were you served with the notice?
My lord, I have prepared my counter affidavit.
What I should do with your preparation unless it is filed?
I may be part. My lord, I am representing for IMD. And IMD is the implementing authority, and my lord, OUAT has recruited the petitioner. So, my lord,
Who appears for university?
I'm appearing for.
Are you continuing his service?
He is continuing his service.
But you are not, don't want to pay the salary.
This is,
They have given the budget.
we have sent the into the IMD, that is opinion number 2.
When are you processing the
sanctioning
bill?
my
authority.
lord, that instruction I have to take, my lord. I have prepared this counter affidavit, but my lord, we are waiting for an instruction from the ministry that whether 1, 2, and 3 will file this affidavit conjointly or only the 2 will file. My lord,
You take your own time. It is a big decision to launching satellite. Therefore, many ministries have to be involved in
my lord,
decision.
my lord, it will be answered conjointly. My lord, I just pray for a very short time.
No, unless order
it has
is-
been prepared, my lord.
Huh?
This has been prepared.
I believe you. You not tell this one. But question is, when were you served with the notice?
My lord, it is.
When were you served with the
24,
notice? Your rules prescribe, rule 11 prescribes only 1 month, 1 week.
Earlier counsel is no more in the panel. It has been
that-
allotted to me, ma'am. I have taken all the instructions to, and I have just a short time. I'm only praying, my lord.
Friday?
Within 10 days, my lord. Within 10 days. Monday, my lord.
Monday.
Next. Deep low, please. Let us proceed to.
Yes. Continue. I'm just thinking, I'm just making all you also to think and contribute. You can sit down, kindly be seated. If interim orders are not obeyed, I'm thinking to strike off the defense. Otherwise, contempt, this, that, etc. In that only a whole time will be spent. The lifetime of the litigant will be spent. Wherever there is interim order, you should obey the interim order. Except in very extreme cases, we can understand. If interim order is not obeyed, no question of counter. You will not be heard in the matter at all till it is obeyed. Just somebody may think and give some note whether it is, what are its pros and cons. Just, okay? Yes, sir.
Sir, it is a
You can
matter.
sit and argue. Sit down. Sit down and argue. Yes.
My lord, it is a matter of fact. My salary has been withheld in absence of higher authority's order.
What were you?
By the BO Kasinagar, who is OP number 6 in the petition.
This has come for admission today.
No, it is for orders.
Orders. 7/4/24 to 21/1/25.
Sir.
Salary is not. Sit down. Sit down.
With the zero salary, the HRMS generated sheet has been annexed with this petition, sir.
Who should pay your salary?
District Block Education Officer, OP number 5.
Provided he has worked for the period.
Huh?
Provided he has worked for the period.
No, he says he has worked.
No,
He has not worked.
I think he has not.
No, you cannot think like that unless you file objections. Any objections are filed?
Your Lordship, before that, I would pray your Lordship to see the order dated 6/5/2025. Passed by the coordinate.
6/5?
2025.
So you remained absent from 1/2/2025 to 9/3/2025 without any leave application.
Yes. Nothing, sir.
No, you have not made application at all.
Sir, I had been get salary from the 22/1/2025 to 31/1/25. And sanctioned drawing by DDO come block education officer OP number 5.
Correct.
Which is seen in the annexure annexure 52 of this petition as a HRMS sheets.
Are you permitted to rejoin the duty now? You have rejoined, you are permitted to make details.
As on today, they are refused my journey report.
No, it is not a fact.
Please gone through the facts, sir. Process, sir.
He is not yet removed from the service.
No, he was not removed. He is not.
He is not yet removed from the service.
No, he was not removed. He is not removed.
Therefore, when will you go to reporting for duty?
My lord, it is a fact is that
we are asking you. When go step by step. Return the service.
The opposite parties are objected me not to going to join duty. On dated 7/5/2025 of this honorable court order.
All right. But now we are sending you to the duty. You accept, you go and report for duty.
Yes.
Now, salary will consider, first you work there. Sir, consider that where there is no constitutional rule for I am marking with a zero salary from April 7 to 2024.
If somebody will not work,
Sir, it is very clear. The BO OP number 5.
We will look into.
Sir, one paper. The BO and the headmaster no locus standi to held of salary as per letter dated 14/5/18 of this Odisha government. School headmaster. Please refer that, sir.
Now,
why we are discussing about pleading here? Sir, please see that, my lord. It is a very clear order.
Now, your name
yes, order, sir. I am open to your orders.
He had
51 of 187 page, sir.
Sadanand Naikji, Mr. Sadanand Naikji. Now I am making a prayer to you.
Nice, sir. I am the servant of Radhakanta Mahaprabhu.
Now, Sadanand Naikji, you do one thing. You go and report for duty.
Sir,
you accept it in the report.
Before
then we will
let him go before the DO, concerned DO.
Go before the DO.
DO, sir.
Let him go. District Education Office, Gajapati.
Okay.
Okay, sir.
And they will accept your duty report. Then you go there.
My lord, this arrangement was made earlier. Again, he didn't join, and thereafter he filed another IA before the court. Honorable court didn't accept his IA.
Now you accept his duty report because he is not yet removed.
He is not. He is still in service.
Therefore, permit him to work. Then what should happen for the absence period?
Definitely, yes.
We can examine that later.
Yes.
But should not keep him idle. He is a very active person. Make use of him in the institution.
Let him join, no problem. Will he join tomorrow, my lord? I shall ask.
You go there tomorrow.
Tomorrow?
Or you will go now only?
No. Tomorrow. Tomorrow.
Pending examination of the grievance of the petitioner as sought to be made out in the petition. Petitioner is directed to go and report for duty in the office of District Education Officer
Gajapati.
So Gajapati at 11 a.m. tomorrow.
Yes.
At 11 a.m. tomorrow. First time.
My lord, let him say at what time he will go.
Well, no, 11 a.m. he should go. He should be there by 11 a.m.
I obey all the orders of this.
Disobeyed earlier. That's why I am saying.
That is not disobedience, sir.
All right.
VO and headmaster could not exercise OCC.
If 1 second, listen to my order here. It may help you instead of altercation. If petitioner reports for duty as directed, comma. The duty report shall be accepted by the district education officer, who shall send an intimation to the registry in that regard. Week. First term. Petitioner and the DEO are expected to conduct themselves tall and honorable with each other, and nobody shall create any issue in the office. Okay, issue for ruckus in the office. First term. Next paragraph. It is open to the DEO to videograph duty reporting and the conduct of all officials, including the petitioner herein, for the purpose of adjudication of this case. But he will not try to look at me. Yes. You go and report for duty tomorrow. All right?
I may please be favored with this court order today.
Court order immediately.
Unless it is not
Forwarded to me also.
Carbon copy of the order shall be furnished to the petitioner party in person and to the learned EGA as well for compliance. Again, copy to be web copy to be acted on in addition to that. Okay. Where will you be? That copy will come to you. You sit in the bar association. We will send copy to you.
Okay, sir. Thank you, sir.
Prepare that copy and send that copy to you. You sit. Which next date you want, sir? Which next date? In the first week of September, we will keep for hearing.
Okay, sir.
Or second week.
As per this, my lordship's order.
September. Which date you want?
September. As per your desire, sir.
I will be here.
Look, it calendar.
24. 24.
As per your desire.
September 24.
Yes. You send a copy of the order to me. Okay, carbon copy. Okay. Yes.
Item 43.
This is that case, Order 45, Rule 15.
Yes.
And they were supposed to address your lordship on the point.
Yes, sir.
I've prepared the.
They are prepared.
After lunch.
After lunch.
Take some time.
Yeah, it will take some time. After lunch, will you be free? I will pick up. Yes, next. Pass over.
Item 44.
Next. May I please, Lord, some Lord. Lord. The grievance of the petitioner is that, my lord, she was engaged as education volunteer in one-day visit of the ADM. One-day visit of the ADM mentioning that she was found absent. So her service was categorized as improper. Therefore, against that order, I came before this honorable court. This honorable court directed that the order of the collector merely the one-day visit report is not cogent because it is cogent material. Because I would have Lord similar that the closure of the center has a wide range of ramification. I must not go. Then after this honorable court, then that against that order they went in writ appeal. The state went in writ appeal. The appellate court also says, well, the order of the honorable single judge is quite okay, and to reconsider. So while reconsidering, they have passed the same order, which is just nothing but a replica of the earlier order. Except one-day visit report. The collector relied upon the one-day visit report of the ADM, which discloses that.
Why were you absent actually?
Pardon me?
One day. Why were you absent? What the reason of absence, for absence?
My absence. Therefore, my humble service, I was not asked also. That my second part of argument, that I was not given opportunity of being at which I could have explained.
No, we are asking you now. Explain to us.
No, my lord. The ADM on this part of, on the moment the ADM visited, inquired as to whether where I was very much present in the center, but the ADMs recorded that I was absent.
Why he will write
Unaccepted.
Can we come after lunch?
Yes. Lord, I beg your pardon.
Any objections or fight to this petition?
Madam, how much Monday, my lord? After lunch, my lord, Monday. I have some problem, my lord. Monday.
Monday.
All right.
My lord, may I take the privilege? 7. I have intimated to my learned senior because AG to address this matter regarding that water cess under the Indian Odisha Irrigation Act. May I pray for first week of
September?
I have intimated to my learned senior.
Yeah, concept. No, 47.
And
The second week of September, Mr. Monty.
Yes, second.
But there is entry order now. No entry order. Second week, some date you can give.
And the request.
Choose some date, whichever date.
Yes.
Okay. At the request of AG.
10th, if possible.
10.
Grateful.
Yes. You want next week? You want to do next week?
Obliged, my lord.
I may be pardoned, my lord.
Because of the, I know that I should not have made a mention of her memo mention.
There is urgency, you can mention even in the mid of
That's why there is a threat
Suppose
of
some building is being pulled down.
the threat of termination from service of the teacher on the basis of a report from the Tahsildar. The caste certificate has been cancelled, irrespective of the fact that I have, after my filing of so cause that I have preferred an appeal before the collector.
What are you arguing the matter or you want posting?
My lord, I want posting.
Posting?
Yes, ma'am.
Tomorrow we'll have that.
Can it be today last case before rising? Can it?
Today we have difficulty because we are in the meeting. Tomorrow late.
Tomorrow, man. I'm
If there is urgency,
yes, sir.
even at 4 you can mention because court is there to serve. We can't say that you should. It all depends upon urgency. Suppose somebody is being hanged, can we say bring a matter tomorrow along with his dead body?
I'm grateful.
There is nothing like that.
My lord, मेरा एक सबमिशन है
In person.
हाँ, 61 आइटम और एक दो दिन बाद item 61.
What you want?
Date 22, my lord.
28 you want to argue?
22.
22nd you want to argue?
Okay.
But 22nd we have many matters now. We'll have it in the first week of September.
Okay.
All right.
Obliged.
On some day. You party in person, give date also.
Special officer. My lord.
As per the staff report, and it will be there in division concern.
Not before us.
My lord, that I am clarifying. That is a wrong SR been paid.
What is this matter about?
This matter is about undergraduate admission, my lord. And my case, Annex 5, my lord, kindly see. The prospectus for admission into undergraduate program. And undergraduate program cannot be a professional course or technical. My lord, kindly see there is a regulation of 2007 where 12 categories of courses have been identified by the government of Odisha as professional. Well, this is the book. So that courses are engineering and bachelor, master in computer application, medicine and bachelor surgery.
They alone are professional.
They are professionals only.
This is not.
This is a graduate program, undergraduate. Yes. My lord, prospectus I have 5, my lord.
So
Yeah.
BSc honors horticulture is not a
Horticulture.
professional.
Professional, that is a graduate. Then this honorable court has the jurisdiction, not in a technical or professional, that is the in classification. And that, my lord, that regulation speaks about 12 type of
Where is our,
professional technology, even if law is not there.
which matters are allotted to me?
My lord, this is the book, this is the regulation.
No, not that. We have Honorable Chief Justice has assigned matters, na?
No, technical and professional, is not a technical and professional.
Not
That's a
correct.
wrong assertion made. Why that made, my lord, I will justify before your lordship.
So it is not neither technical nor professional.
Professional. Because the undergraduate program. My lord.
Yeah, same.
My lord, kindly why this is the confusion that I will clarify.
No, we'll go to merits now.
Yes, my lord, I'm submitting on merit. Orissa University of Agriculture and Technology, my lord, that is the university of the government, that is controlled by the government university. My lord, there is a program in other rural area and giving 2 years program that they are treating it as, those are 2 years they have taken as diploma. That is Annex 1 phase 9. But this is only diploma in agro polytechnic horticulture science. They are eligible for BSc agriculture, to study BSc agriculture, which is the undergraduate program.
Which is the last date for admission?
My lord, that's continuing. My lord, kindly see.
No,
there
you have
is-
to answer the question.
My
You
lord,
cannot run away from that way. You
That
have
is-
to answer the question.
they have fixed it on 16th. Now it is continuing.
Continuing.
My lord, my case is before your lord. They have entered a entrance examination, selected through entrance.
We will issue notice to the university. We'll call this matter day after.
My lord, obliged. My lord, obliged. But they are not accepting copy, OUT lawyers, because
We'll
panel
issue
lawyers
emergent
are there.
notice. We'll issue emergent notice.
Yes, the
Okay.
government. Why not let government to
Issue emergent notice. KGA to accept notice for
notice for
OP1.
OP2, OP3, my lord, that is the registrar or chairman academic council.
No,
With
the
opposite
government is a party,
Government is not.
not a party.
No.
Why you not putting? Issue emergent notice.
Special messenger notice, that is called. I will
First,
text.
in addition to taking usual steps, Shri, the panel counsel Shri so and so may be served with the copy of the petition along with all the documents. First, since urgency is pleaded, call this matter on Friday. Okay. Yeah. 43.
Item 43.
Yes. Any objections you have raised?
Yes.
Give that. Have you received copy?
Just serve the copy, just within 2 minutes back.
Then we'll have this matter some other day so that you can go through the objection.
Let them place what, if anything is, because in 2021, they had filed a counter affidavit, which is verbatim reproduction of what they are filing today. But anyway, can we have it tomorrow, day after tomorrow?
Tomorrow, we have some urgency matter.
As your lordship.
We'll have this matter on 25th.
I will go. I just have a prayer, Lord.
Yeah.
Can we take the LCR in my pen drive? The Lordship has to order.
You want copy of that?
Yes.
Registry to supply copy of all the documents online in
Pen drive.
through in a pen drive form after accepting necessary fees therefore. Okay.
Right.
From the
CSTEC here decide.
Huh?
I think it's given free of cost. That is,
if there is we do not know
that is what is usually.
if any. Okay.
45.
Yeah. Justice is free because Magna Carta of 1215 said, to none shall we sell,
The Bill of
none
Rights.
shall we delay to none shall we deny justice, but not these materials.
No, but we are supplying the pen drive. So they have to just push it and take it out.
Yeah.
Item, my lord. Item 45.
Item 45, my lord. I beg pardon, my lord, I am in BC. But by last order, I was implemented as the opposite party number 4. I was to file the counter affidavit. I prayed 2 weeks more time to file the counter affidavit, my lord.
6 you added, na?
My lord, opposite, yes, my lord.
Yes. On 24/6, now 2 months are over. Under your rules, under Rule 11, only 1 week is given to you.
My lord, 1 week more time I want, my lord.
You cannot go on like this. We have to follow rules are made for.
Yes, that about, my lord, after I was implemented as a party, petitioner should have served a copy so that I can file the counter. That they have not served also.
Sir, a copy of the petition on them.
And they have not needed any copy. They have already obtained the copy and filed the interim application.
No.
I will, sir.
Serve copy of the petitioner to serve copy of the petition on the newly added OP number 4, so that OP number 4 may file the counter, if any, within 10 days. Call this matter after 2 weeks.
Item 46.
May I please, my lord? This is a case, my lord. I need to again refresh, my lords, about the factual aspects actually. If my lord can take note of few things, my lord.
Yeah.
This relates to, my lord, allotment of a plot having a larger area. That is a crux of the issue, my lord. My lord, may kindly take note of plot number. Your lord,
There were 2 plots.
2 plots.
One
was the larger, bigger.
You wanted the bigger plot.
I applied for smaller one. I emerged as the highest bidder in respect of a plot that measuring small size. There was no prohibition also to apply for the second e-auction. I applied.
They rejected on the ground that, as you rightly argued other day.
Correct.
Because it was some 23 February, something like that. And
one day, I had to eat. It was sent. Next day, auction was opened. The reason probably, my lord, directed both the parties to explore the possibility of settlement. With due respect to that observation, my lord, though I attempted,
it did not help.
My other side is adamant, my lord.
No, we can't say that because it's a statutory body.
It was between the 2 of the allottees.
Other side means other allotee.
Other
allotee actually. So,
we have already allotted the plot in question and deputed that amount, and that has been accepted 2021.
2021.
Yes, ma'am. 80 lakhs are deputed.
You have already paid it.
Yes, ma'am.
When you paid 18 lakhs, let us, 1 minute, we will come to you. Let him argue the matter.
So kind of you.
Yes.
My lord, 28 developed plots were developed by Bhubaneswar Development Authority, my lord.
Yes.
One plot number K, oblique 4/1306.
K, oblique
4/1306. Measuring an area of 1250 square feet. The scheme was floated in name and style of Kalinganagar Plotted Development Scheme, my lord.
This is one plot.
One plot.
Another is?
Another is, my lord, plot number K-5/477. Measuring area, my lord, 2037 square feet. 2037 square feet.
You had applied for on a first site is K.
I will come to that.
K/4.
K-4/1306. Another is K-5/477.
Okay.
And my lord, another plot number K hyphen 4 by 426.
Yes.
My lord,
This measures
that measurement, my lord, is
2057.
2057. 426.
1.00.
Now, my lord, for the first plot, K 4 by 1306, E option was held on 10/3/21. The petitioner emerged as the second highest bidder.
auction was held on
10/3/21, 2021. Where I emerged as the second highest bidder.
H1.
I am the H2.
H2.
Second highest bidder.
Second highest. Yes.
Bhubaneswar Development Authority, my lord, issued another development scheme in the same name and style, my lord, where plot number K 5 by 477 was one of the plots, my lord, measuring area 2037, where also I applied, and e-auction for the said plot was held on 25/3/21.
Yes.
Where I emerged as the highest bidder. Now, my lord, in writ petition, while challenging order under Annex 6, my lord, there they said that because the first plot in respect of which I was H2, the H1 refused to take that.
Therefore, you should have accepted the.
I am bound to, I am forced to accept that. And because of this forceful acceptance or acceptation, my lord, I become H1, and otherwise I am disqualified to participate or to claim for any successive auction. My humble contention is, my lord, if your lordship could,
Which is that?
if your lordship will kindly peruse Annex 6 of my writ petition at page 20.
Page 20.
My lord, of my writ petition, my lord.
20.
There a request was made to me by the PDA, request to deposit remaining EMD. There, your lordship would see, I am reading that, my lord. You have been considered a selected bidder. My lord, may take note of the words. You have been selected bidder in respect of plot number K 4 by 1306 in the e-auction held on 10/3/21. Further, you have been intimated by letter so and so to deposit the EMD, my lord. You have not deposited the amount, the second paragraph, my lord. However, you have again participated in e-auction dated 25/3/21.
Yes.
And sent letter dated 26/3/21 to consider your case for plot number K 5 by 447. Here, since both the dates are mentioned, my lord, without any distance, for your lordship's convenience, the letter they sent was on 23/3/21. E-auction was held on 25/3/21, second e-auction, my lord. Correct, my lord?
Yes.
Now, thereafter the meaningful paragraph, my lord, it may be mentioned here that since you have already been accepted in a selected bidder earlier, your candidature have been cancelled in respect of e-auction held on 25/3/21 by the empowered committee on allotment. However, you are eligible for refund.
This letter is sent to you on 22nd.
22nd 4/21.
Yes.
This is under challenge. Now they filed a counter affidavit, my lord.
I'm taking your lordship straight to paragraph 4.
Now, what is the ground on which you want to alter this?
Now, my lord, now they probably highlight two grounds. Once I somehow other, if I become
Under which rule the H2 becomes H1 by deeming, which is that point.
if H1 actually refuses to
withdraws.
accept the proposal, it is their brochure, my lord. The condition, the first brochure I do not have the copy, but second brochure I have been provided since I did not have it. हाँ देले अपन देले कौन टा देले भी देखे दो.
You are saying
ये देले. हाँ देले सब रखो जी. First day ना जी repeat करो.
I am आर्थर कहले बोली आपनको आउ गोटे I have given another copy and
So is bereft of the first. You say the convince कर जाए पड़ेगा. ये मुझे भूल गया more handwriting.
I am asking you, your impugned letter proceeds on a premise that there is some policy decision or norm binding on the participants in the auction, that in the event H1 withdraws, H2 goes to his stead.
yes. That's
Where is that?
There's my counter brochure I've given my counter page 15, internal page 15.
Huh?
My counter internal page 15.
Your counter.
Internal page 15.
Annexure 6. Which annexure?
There's annexure, counter annexure, that is
Probably A by 2.
A by 2.
A by 2. Does it say so?
Yes.
This is the
In what circumstances?
Which paragraph? You just take me to that paragraph. Your brochure is a long brochure. I
Kindly look at 6.8.
8.
6.8 match.
Mode of allotment.
Yes. Successful bidder methods.
0.8.
6.8 minus. In the event, I read minus.
In the event of one bidder pushing the highest bid for more than one asset and becoming the H1 bidder for 2 or more assets at the closure of the he will be successful bidder for only one asset for which he has quoted the highest higher amount other assets of the highest bid should cancel for the fourth position. The second highest bidder shall be the successful bidder. Kindly read that portion. In the event of.
In the event, that starts from that. In the event of one bidder putting the highest bid for more than one asset.
So one person is
can apply for
2 assets.
3 assets.
Here
2 assets.
More than one.
2 assets. And become H1 bidder for 2 or more assets at the closure of the auction process, the e-auction process over.
That means H1 should have applied for 2 or more. And
he is the highest price. The
highest price will be accepted.
The plot in respect of which highest will be taken as other 2 will be excluded. It will be given the H2 bidder will be taken as H1 bidder.
In this case, it happened.
It happened.
How it happened?
It happened means my counter I've stated.
H1 applied for how many sites?
2 sites.
He had applied for 2
sites.
Learned panel council appearing for BB, what is that?
Bhubaneswar Development Authority.
BDA draws attention of the court to paragraph 6.8 of the brochure at annexure
A by 2.
A by 2 to contend that in the event of one bidder quoting the highest bid for more than one asset and becoming the H1 bidder for 2 or more assets at the closure of auction, he will be the successful bidder only for one asset for which he has quoted the higher amount than the other 2. And further that, in that event, bidder next below becomes the highest bidder. First, in the instant case, in respect of site measuring, site plot number A for 41306, there was the highest bidder withdrew from the bid. T2 having applied for more than one site, and therefore petitioner eventually drove himself to his state as H1. First up. Despite that, petitioner having not come forward, he cannot be given any relief at the hands of this court. This is your contention, na?
Well, this matters, so far as this is concerned, two plots matters referred to that person.
No, so you kindly read next sentence.
Srimati Subhasini Swai, the person.
No, that 6.8. Both we have read in
6.8
sectarian way.
6.8. But however, in case the second highest bidder also becomes a successful bidder of other asset in the same auction, then the third bidder quoting highest value will be the full bidder.
Similarly,
the sequence will follow till minors. This is the video closes the principle. The principle per selection will continue in the manner as aforesaid till all assets are allotted to the successful bidder selected through auction or the bid are adjusted. Well, so here in this case, what happened? Well, have already taken note of that. Two plots. One, Saubhagini. Then I'll kind of class to paragraph number 4 to my counter.
No, I just wanted to have clarification. I don't want to interrupt his argument. Let him complete. I'll come back to you. Just clarification I will give. Yes, sir. My lord.
I start from very left, my lord. In the event of one bidder quoting the highest bid for more than one asset, becoming the H1 bidder for two or more assets, it means there was no provision for applying for more than one plot.
Correct.
To be more precise, my lord, I had the freedom to apply for.
And you had applied also.
I further submit, my lord, since there was no provision, no restriction in both the brochures, any person applying for a plot in the earlier brochure also can apply for the second brochure. Let me clarify this background. Now, I admittedly emerged as the second highest bidder in respect of a plot measuring of smaller size,
1250 square feet.
1250 square feet, where I emerged though second highest bidder, but since BDA allowed the H1 bidder to exercise his or her option to go for a bigger size plot, I am being considered as
H1 in his place.
In her or his place. Now being given a freedom to go and exercise option to go for a larger plot from the contentions of paragraph 4 of their counter affidavit. I read that, my lord. Srimati Subhasini Swai quoted highest bid in respect of plot number K4/1306, the first plot where I am H2, and the petitioner quoted second highest bid of so and so. The first highest bidder became also first highest bidder in respect of plot number 4/426. Her to move to 426.
Yes.
Now, if I become highest bidder in respect of a plot, 4-5/477 for a larger area, why that should be allotted to the newly added opposite parties, my lord? The contention that we have deposited the amount, given the amount, my lord, 2021 is the time when the case was at infancy, my lord. Everything was hurriedly done. And look at the day gap, my lord. On 23, I become successful according to them. They write a letter that you deposit the EMD. 25th, e-auction is held. 26,
I write to them that I am the successful bidder. I expressed my interest for the larger plot for obvious reason, my lord.
Articulate your ground, he will take down. Give dictation of your ground.
My lord. My humble contention is, my lord, there was no prohibition.
No, articulate the contention. You tell the ground.
Grounds for challenging the decision, my lord.
Yes. Now you said, na? You said whatever, there is no prohibition for one person to apply under two brochures.
Yes.
For multiple
number of plots.
Plots. If a person of plots is found to be the highest bidder in respect of one of them,
then he
can shift to
the highest bid where
the
he is
highest bid. And in that bid, who is next below immediately, that is H2, will become H1. That is his contention.
That is his contention, my lord.
Do you dispute that you became H1? You became H1 in respect of 4/1306.
1306.
Yes.
Yes, I know. In terms of this clause, my lord.
Yes.
After someone exercised her option to go for a larger plot, my lord, according to BDA and as per the brochure, I am being treated as successful bidder, not H1, but successful bidder, because I am H2 admittedly, my lord.
That's what.
So I am elevated. I am elevated
to H2.
You treat me H1, no harm. But actually I am H1 in respect of a plot. In terms of your own brochure, my lord, I should be allowed to.
No, that happened only on 20.
Let us say on 25th.
25/3/20.
25/3/25.
This happened on.
While traveling from 23 to 25, my lord, my humble contention is there is no bar to go further. There is no bar to also participate in 25/3. There is no prohibition, my lord. The same clauses are also there. The exact verbatim. Copy paste, my lord, for the second brochure. There also I am H1. And look at the time gap, my lord. This time gap gave some breathing scope to BDA, my lord, to select the chosen one, the favored one, my lord.
You were informed on 23?
25, if I am not wrong. Confirm, my lord.
You were informed on which day?
My lord, I was intimated on my lord, this is 22/4/21.
24/2.
No, this is not, this is the Annexure 4 is the.
No, it cannot be.
No, definitely not. Annexure 4 is 23/3/21.
23/3.
For deposit of remaining EMD for consideration of provision. And my lord, the second.
That was in respect of 1306.
1306. Correct, my lord. 1306. Now the question arises, my lord, when he or she exercised the option, my lord, that is relevant. Because the picture was clear. They took mean advantage of this clause, my lord. They told me to be the selected bidder forcefully.
What was your bid and what was the other her bid amount? Bid amount.
Bid amount in respect of, my lord?
Yes.
In respect of
in respect of
where I emerged as the second highest.
477.
477. 477, my lord.
A5 477.
Where I emerged the highest bidder.
Yes.
My lord. My lord. That also I have deposited. It should be 5.
No.
By bidding an amount, I bidded an amount of rupees 86,63,000 Paragraph 10 of my writ petition, my lord.
86,63,000. 860063.
Yes, yes. 8663,000.
Huh?
8663,000.
And his bid was, her bid was? Her or his bid, I do not know, I am not on gender.
Which one? The second one, my lord? Second one, she or he was never not in picture. Who became the second highest, I don't know.
What was the amount for which you have given the other plot to?
So far as that K5.
The plot I am now interested.
K5, my lord.
K5.
K5,
What
it
is
was,
the amount you have received?
it was amount, my lord, so we have received that, meanwhile, he has deposited an amount rupees 80 lakhs 3,016. 80 lakhs 3,000.
That's the bid amount.
Bid amount.
80
800
800
300. 80 lakhs 33,000.
80 lakh.
Five.
3,000. So that will cause loss of rupees 6 lakh to your organization.
That will cause loss to 6 lakhs to our organization, right, my lords? So if it will be compared along with the petitioner's offer.
He wants to give higher,
higher, my lords. But
and you smaller amount by interpreting this policy.
The principle is that, my lord, that is what, my lord, that is the case. The principle is that
the object of holding auction, the Supreme Court says,
so maximum augmentation of resources.
Where is the maximum?
The fact remains, my lords, here we are bound by a principle.
What is that principle? Your principle cannot be to the detriment of the
That's correct. That's correct, my lord. Can visualize one thing. So far, his offer in respect of the earlier one.
Yes.
Niranjan Mishra. But it was 86,63,000.
Yeah.
So, my humble contention that if he will be allotted that plot and will be paying that money, I think it will be compensating. But fact remains what my lord says about the particular plot. The thing is that, my lord, so the principle is that, my lord, so the person concerned who has availed one plot cannot avail the another plot. That is the closure condition.
That is there are competing principles.
The competing principles are there, my lord.
Competing principle. While competing principles are there, you have to choose one of them. Because they compete with each other.
Whoever will quote highest. Whoever will quote highest, that is the principle. But here in this case, my thing is that once the auction process is there, we are not limiting it. Maybe right or maybe wrong, my the principle, that is a different aspect altogether.
But here to decide right and wrong only.
But I'm coming to that. That is not under challenge. Only thing is that they say that I was the highest bidder of the second plot. Second optional plot was advertised through second notice, auction notice. He was allottee of plot number, can visualize. He was allottee of plot plot which was subjected to auction in the earlier auction. That earlier auction.
Not earlier auction.
Earlier auction.
It was first 25/3/20.
25/3 was the 25/3. He plays probably I'm unable to some.
The first auction was on
first auction. He got a smaller size plot, quoted higher value.
We will not go to that level. We are on the date.
Yes.
The auction took place on 10/3/2020. And he was not the highest bidder.
First auction.
First auction.
Yes. He was the second of.
Highest bidder withdrew.
No, not withdrew. He becomes.
He got another highest bidder. The other
got a higher amount and he got another plot.
What he says is same principle is applicable to him. So, that is his case.
Probably, I'm unable to convince my lords. There are two bidding process. two advertisement, two bidding process, separate bidding process. We're on fast bidding process. Insofar fast bidding process is concerned, the petitioner quoted in respect of one plot and other that what is that name is?
Other plot is 5/477.
Subhasini Swai. He quoted highest in respect of this plot. But a smaller size plot. Smaller size plot per square feet, the value would be more. But smaller scale, when he became successful in respect of another bid where he was quoted higher than this amount, then he was selected for that. That plot number is 4/426. 426 he got.
Yes.
But thereafter, he became the highest bidder in respect of that plot. Now question is that plot, he quoted that amount proportionate to the minor's area. Minor can visually compare it to in respect of the area. So there, that few pinches, the area. So for area is concerned, per square foot, his value would be much more.
But that is not the ground on which you have done that.
No, but we have done it on the ground that you got one plot allotted earlier.
On that ground you have done.
We allotted you one plot. You got successful in that. In view of the brochure condition, you are now the successful bidder in respect of that plot. Once you got that plot, you cannot get that plot even if you participate or you can quote the tender. You cannot get it because that is the brochure condition. And once somebody got selected, that I am putting that.
You come to, is it page 30?
Page 30 minutes.
Page 30. You have not mentioned the figures at all. Para 4.
Para 4 minutes. Minutes.
His bid in respect of. How it begins? Sentence begins as?
His counterfeit bid. That is clearly empty in my copy.
It's empty in your copy.
My copy is empty because no figure.
Then, my lords, I'm sorry, my lords, I can't say that, my lords, this is kindly visualize one thing, my lords. This is the copy I've given, and this is the memo which has been given to me, my lords, receipt.
But in our affidavit also it is empty.
Empty? Then, my lords,
for judge to fill up.
My lords, so far as that last time my learned friend pointed out, and I require my clerk to immediately serve it. My lord, that is the copy I serve, my lords, and along with Annexure B2, my lords, kindly glance to that copy, my lords, I have served this.
What that copy? In our papers, where
if that is not there, my lords, I am in fault.
No, I am not judging whether you are at fault or not.
This receipt is genuine, correct? And there also he has clearly stated from paragraph page 27 to 45, 29 to 26.
Last time you said that you have not got B2.
No. Did I say that, Paul? I said the brochure copies are not with me.
No. The brochure copy. That is the brochure copy.
And A2 is not the brochure copy.
Just a minute, what my lord says.
Judge's duty is to decide the dispute brought before the court between the parties, not between the lawyers.
That's right, my lord. That's what I said very kindly.
You have not given the figures at all. Then without those figures, how to treat this matter?
So, may I beg, my lords, if that brochure, that annexure is not there, I will be substituting it, may be taken up tomorrow.
Well, how many times I should go on hearing this matter?
Because that document is not there, I cannot, my lords, request my lords.
Let me excuse me those figures, because on those figures I have to structure my judgment.
And my lord also may express the concern, my lord, when the currently added opposite parties. Snehalata is not the opposite party in the writ petition.
Snehalata?
So let us not be confused that one who shifted her option or his option is
not a party.
Explain what. So the newly added opposite party, my lord, when she or he came to picture is irrelevant for my lord.
No, that is exactly what my lord says.
Which is that judgment of the apex court when there are competing principles.
My lord, best possible price theory.
I
will come with that also.
The judgment is there.
There means it is there.
That will succeed on everything.
Public lodges, public lodges should be put into auction. Sorry, is the highest optimum value, whatever it may be.
That's best possible.
That is there, my lord, that no dispute on that. But here in this case, my lord, the concern and predicament, my lord, my humble contention only one that we are bound by the brochure conditions.
Can anybody Google out that judgment?
That judgment, my lord, I think in my hand.
The object holding public auction is to ensure
I will get it.
transparency
My-
and
I will get it.
raising of highest money.
Yes, madam. That is in my note khata, madam. I will get it, madam.
All on. 20. First, no, very old judgment.
That's a
Justice
it is of 70,
judgment.
74 or 75.
Much before. Justice B.K. Mukherjee's.
So that the referring to another decision is 73 or 74. I will get it. All these references I am with
On 15/9.
My lord is hinting at Ramana Dayaram.
Adishati. Raman Dayaram.
Ramana Dayaram, yes.
That's also one paragraph.
That is the foundation, my lord. Thereafter, we all improved, my lord.
That has been elaborately discussed in
80
subsequent.
Supreme.
80 Supreme Court.
That has been elaborately discussed.
Right.
18 or 70.
No, 79 or 80. It is reported in two reports. In STR, it is 79, and other is 1980 Supreme.
79, madam. 79, 128.
Raman Dayaram.
Raman Dayaram
It is International Airport Authority.
Raman Dayaram Setti.
May 1979.
No, it reported in,
International.
we'll have it on 9th of September.
9th of September. Kindly report 2 days before 9th of September.
2 days on Sunday, I have to say.
9th of September.
You say another 11th of September.
We commencing 15th, my lord.
15th. No,
Commencing
15th of September.
Minors annexes are not there. I undertake minors to get
And
it.
enter the values also.
I will enter that. I will also give the particulars of these valuations and all this. I will give them. No problem.
Because this is affidavit.
Yes, madam.
Affidavit itself is blank,
Yes.
though it is sworn to.
I will give it. But probably it's unfortunate, madam. So it's admittedly a fault in my part.
Hurriedly the decisions, my lord, will always bring in suspicion.
No, it's not a concept of horrid. Counter means horrid decision means so far that taking decision to allot, not that filing counter.
He is always humorous. You take with some humor.
Yes, that
Humor is also necessary.
That's life.
Homer said.
Homer says, in fact, with due humility is the lifeline, minors. That gives us a lot of pleasure. Reduce burden, stress and burden.
Item 48. Yeah.
48 is yours.
Yes.
My lord, it is an application of the letter, compliance letter of OP number 4, man.
Letter?
Letter 1702/WC, letter 13/5/2022.
What that letter does to you?
Letter is in a compliance manner in respect to the contempt earlier filed. And in this respect, earlier a writ petition was filed for disposal of the representation of the petitioner. And in that respect, the compliance is which is a letter given by the executive engineer, which is OP number 4, my lord. And that in respect to the road of public, and forcefully that OP number 4 illegally constructed the road on
Illegally constructed
wall,
which
boundary wall
on which property?
on the road, on the passage road of the petitioners.
Public road.
Public road.
Public road or your road?
No, madam. That is a road, government road occupied by the government, and it is passes road for the petitioners also. And it is very longly that road was used by the petitioners and villagers of Galpur Gram Panchayat, my lord. Now the OP number 4 illegally constructed the boundary and squeezing the road arbitrarily, my lord, which is inconvenient.
What was the breadth of the road, width of the road?
As per the letter, they have provided in annexure, my lord, kindly peruse. Annexure 1, my lord.
Yes, brother, what do you say?
Lord, here the petitioners is before this Hon'Ble court. They are the inhabitants of the village. It is in PL in nature. However, so far the road, it belongs to the government. The judicial quarters are there. In order to make it a convenient area, they have made this boundary wall. They are saying as it is a regular, they should pass through the same, even though other roads are there. So by constructing the wall,
who has constructed that wall?
The OP number 4, the engineer Mellard, executive engineer Bhadrak Mela.
Government. Government constructed it.
Government constructed for the boundary wall of the judicial quarters. Judicial officers quarter at Bhadrak. They are saying, as we are passing through all these roads,
no,
so
this road is not, it cannot be used now.
This can be used.
What was the actually width of that
the
road?
The width is length and width is 11 feet by 7 feet.
11 links, 15 links and 17. 1 links, my lord, 11 links, my lord, approximately 7.26 feet.
Yeah.
But as
and
per the
judicial quarters are also government property only.
Yes, ma'am.
Yes,
to protect government property, perhaps to protect judges also. They have.
But there is ample space, my lord, and that road is earlier. That road is made, and it is passes for the public.
No, still the road is you can use the road.
Only the allegation.
If you want to take 72-wheel vehicle, it may not be possible. But for your car, for your bus, lorry, you can make use of that.
That road is not maintained, not passes. Even ambulance or fire vans cannot pass through it and
Where have you stated? Where have you stated?
Petition, man.
In the petition, have you stated so?
Yes.
Which line? We will send some lawyer from our bar to see that road, whether ambulance will pass or not.
Yes, obviously, my lord. As per the letter.
What's in that letter? Now we'll ask them. We leave all the pleadings. Pleadings are not most of the pleadings are substandard anyway. Now we will appoint a commissioner. You pay 5,000 rupees to him. Let him go and see whether any ambulance can pass through or not.
Yes, ma'am.
All right.
Yes, ma'am.
Who will go now? Any youngster, gentle ladies? Yes, who will? That's better. Ladies will not lie.
Yes, ma'am.
Yes. Call somebody. Anybody.
Raiguru is there, Miller. He can.
You will go. The bone of contention in this matter is as to the squeezing of particular road, and according to the petitioner, because of that squeeze, not even ambulance can pass through the said road. First off, learned AGA Mr. Mohanty contests this assertion. First off, pleadings in that regard are lacking. First off, therefore, it is desirable to appoint a court commissioner to undertake spot visit and exercise and measurement exercise and come back with the report. First of all, on the request of the court, Shri so and so has agreed to be the court commissioner. We shall accomplish this. First of all, petitioner to pay rupees 5,000 by way of commissioner's fee for the task in question. Yes, you pay
Pardon,
you deposit that 5,000 rupees. You have to deposit in the registry. Registry will release it.
Yes,
Otherwise, you may give 10,000 rupees to have a okay. Also, petitioner to deposit rupees 5,000 in the registry within 3 days. First, petitioner shall undertake the exercise after getting this money from the registry by moving a memo. First, call this matter on 21.
Pardon, my lord.
So for the OP number 3 is the Tahsildar. Can he take the assistant? Because earlier occasion,
can take
exactly. Unless there is a order, he can take the
It is
assistant.
open to the court commissioner, who is an extended arm of this court, to take the assistance of
OP number 3, the Tahsildar Bhadra.
OP number 3. OP number 3. 1 or 2 surveyors,
Yes, exactly.
if needed.
My lord, ambulance and fire vans maybe included fire vans for escaping the
thing.
Thereafter, you will say road roller. Ambulance and fire extinguishers. Yes.
Now other road
Fire brigade vans. Okay. You pay 5,000 rupees now to the registry. Registry will remit it to the commissioner. No free exercise.
Just subject your lordship. I don't know, 5,000 may not suffice as taxi fare to Bhadrak will be about
No,
one.
this is initial amount. Initial amount of 5,000. Not full fee. The initial amount of 5,000.
And the topography of that area, by that if other common means of communication, everything they can give on the
Correct.
topography of that.
Final bill will be settled fixed by the court after the exercise. You are right.
My lord, earlier maybe deleted, my lord. Is the earlier council? Priyaranjan Mishra, maybe deleted.
All right. You have to pay it within 3 days now.
Yes, ma'am.
Okay.
Obliged, ma'am.
That is initial amount.
Yes.
Then some more amount will be fixed on payment of that matter will be heard. Not otherwise. Okay.
Yes, ma'am.
Yeah.
Obliged, ma'am.
Nothing else, lordships may see the last order of 9/7/2025. 9th of July 25.
Some matter relating to assessment of the property.
Yes, I'll just, my lord, point out.
You have paid excess.
I paid excess. Why, my lord? I'll just point out subject to your.
So that question propped up in what back?
Yes, my lord. What happened is I purchased a plot from BDA. It was a vacant plot. I constructed the house. Then I intended to sell it. So before selling, I have to pay certain charges to the BDA for the transfer charges. So there's a format in that where nothing is mentioned whether like the value of the asset has been, whether it is the land only or inclusive of the building. Nothing has been mentioned. It was simple one line that the valuation of the asset. So I put it at a particular amount of 1 crore. So on that basis, they raised a demand from me that this transfer charges you have to pay for the purpose of selling the property. So after that,
charges is on transfer of entire property or only plot?
Only the plot. So that is, well,
whatever my understanding was, because it was only written as the valuation. So I thought maybe it is including the property, the building built on it. So I made the application by giving that valuation. On that basis, they raised a demand against me that you have to pay on the entire charges, not the plot only, plot as well as the structure also. Later on, my lord, they issued a clarificatory notification that it will be the asset which was also there earlier also, but it was not within my knowledge. So I wrote them a letter that this is what the amount I have paid, but actually it should be this. So the excess amount which I have paid, you may give it back to me. My response was, since you have put the valuation yourself, so the demand which has been raised on that basis is correct and no refund can be granted. So to that extent, my lord, the entire issue evolves around that. If your lordship should come to their counter affidavit, annexure B/1 at page 12. Whether they're making a demand on that basis.
Where is that norm which prescribes transfer charges considered?
Yes, my lord, that is what, my lord, I'm pointing out. Page 12, annexure B/1, that was the earlier office orders, 27/5/2015. And then I'll come to the, my lord, the subsequent which they have also.
No, 1 second. Kindly read it.
Yes.
Pursuance of the authority.
In pursuance of the authority resolution dated so and so, consent charges in case of transfer of assets allotted by BDA.
Assets allotted by BDA.
Yes.
You want to say building is not allotted, don't
Yes. And also, your lordship may continue with that. BDA will be levied at 25% of the differential amount of the asset. That is between the value of the transfer of the asset and the price at which the allottee intending to transfer had paid for the allotment of the asset earlier.
So it must be plot only.
Only plot. That is
you paid taking the value of the building.
Building also.
Which you have put on that.
Yes.
That amount needs to be refunded. They say since you yourself valued it, it cannot be. 71 or 72 of Contract Act.
No.
Give Contract Act to the learned senior advocate.
I'm sorry, my lord. To that extent, I'll
give you. Which is that famous judgment of the apex court, which considered where excess payment is made, it can be recovered. Mafatlal Industries versus Union of India, 1990s. Section Contract Act. Take out Contract Act, section 71 or 72. I studied in college.
72.
72. Read that.
Liability of person to whom money is paid or things delivered by mistake or under coercion. So
by
mistake.
Under coercion. This aspect is considered by the apex court in Mafatlal Industries versus Union of India. In English law, if money is paid in a mistaken notion of law, it cannot be refunded because ignorance of law is not acceptable.
Yes.
But in India, section 72 is interpreted where money is paid either by mistake of fact or by mistake of law. That can be refunded. Just will you look into that judgment?
Subject to your lordship, sir.
Just read that. There are many youngsters.
I'll just read, my lord.
When we request to read, it is not only for you and me, but there are many youngsters
for the bar also. For the bar also.
Yes.
Liability of person to whom money is paid or things delivered by mistake or under coercion. A person to whom money has been paid or anything delivered by mistake or under coercion must repay or return it.
That's the duty.
Then, my lord, the illustrations have been.
Even illustrations may not be of much help to you.
So then, my lord, your lordship may come to my annexure 2.
No, unless you go through that.
I'll. Because this also reinforces what they have.
That is to see, I'm here to do justice. I'm not the umpire for the chess game. What is your defense?
What my learned friend says. That is the point, my lord. Kind of a class to page my counter. Page they filled in. That is not so that categorically for clause 3 it categorically stated reason for transfer, mode of transfer, sale or something, value of transfer. You are
he valued entire property.
There is no such.
Is it your case That entire property is not valued, only plot is
No,
valued.
no, that is not there, man.
No, have you said that?
Yes, that is the transfer. That is the transfer that's sought for.
No, what is the price? What is the value of the site in question?
I didn't question. Value matters in market matters. It matters more than.
They can take only as per the benchmark value of the government that is there.
Guideline values.
Guideline values, and that.
Well, two things matters. One thing is, so far building is concerned, we are not going to assess it. All through matters we charge 25% out of that property, whatever we have. 25% of the difference in cost.
How that reads?
That reads matters in this way that the amount.
Where is that the instrument? Let us see.
The instrument matters. That instrument matters that whatever they have given. Annex
25% of which is that?
25%.
That is, my lord. One I pointed out, Lord, page 12 of their counter affidavit.
25% of the different amount of the asset. That is the difference between value of transfer of the asset and the price at which the allotee intending to transfer had paid. For allotment of the asset earlier. Therefore, very loose English is used here. But anyway, we can make sense. It must be on plot.
So think like this. Suppose I purchase the property at 2 lakhs. Then I'm going to sell it
for 5 lakhs.
5 lakhs. So 5 lakhs minus 2 lakhs.
It will be 3
lakhs.
On the 5%. That's what. That's how it should be. What he says is,
he says, right?
I have wrongly calculated. Taking the whole value of the structure also. In addition to
that is lacking.
No, because the case also should see annexure 1, the form that my friend is trying to.
No, for that now, the bifurcation of pricing has to happen.
Yes, ma'am.
Some exercise has to be undertaken.
They have their officers also. BDA has its own mechanism, or if a lawsuit wants a joint,
we will take out, we'll entrust the matter to some approved valuer.
Yes, ma'am.
Of income tax department.
Absolutely.
Let him assess the value of the plot and work out what is payable by you.
Yes, ma'am.
25% on that. Both are agreeable.
Yes, my lord.
We are agreeable for that.
And that was, my lord, in 2021, what was the market value of that? When I saw
value was released on the date of the my lord's application.
Right now. The petitioner has kindly be seated. Vasant. Petitioner has scripted his prayer as entered. Next. Learned senior advocate Mr. Nanda, appearing for the petitioner, submits that under the mistaken notion, his client has paid the what is the transfer charge? Transfer charge. Kindly be seated. Kindly be seated and answer. This is not primary school. You are all honorable members of the bar. By mistaken notion, his client has paid the consent charges for the transfer in terms of office order dated 27/5/2015, taking the value of the structure put on the plot as well, when what was payable was on the differential amount of transfer of the plot alone, excluding the structure. First, on this principle, there is no much dispute about from the side of the BDA. Mr. Mahapatra from the side of BDA. From the side of BDA. First, it is quite right because the office order in question reads as a next paragraph. In view of the admitted position, the principle akin to Section 72 of the Contract Act 1872 as interpreted by the apex court in
89 SCC page 1 also look to me.
Mofathlal Industries versus Union of India. 96.
89 for SCC page 1.
89.
The money was paid under a misconception.
It has to be paid back. That's what Nariman's argument was.
Mofathlal is 96.
1996. 96?
Yes.
1996 it is.
1268.
1268. 1268. What have you written now? Read. Section 72 of the Indian Contract Act 1872, as interpreted by the apex court in Mofathlal Industries versus Union of India, so and so. The exercise has to be undertaken to demarcate value of the plot in question, market value of the plot in question, as on the date the transfer took place.
No, as
that was in 19, that is in 2000?
my lord, 2021. Transfer has not taken place because of that. But on the date the application was made for transfer of the asset.
But the differential of the transfer.
Differential of the
not application.
No, because after that the sell deed was not registered by the authorities. That permission was not given. So that is why my lord.
Precondition for the sell deed?
Yes, ma'am.
Where is that?
That is why my lord.
That's a precondition.
Precondition. Yes, and that is why my lord to give NOC to me, and the sell deed was also made in.
Tell the date.
If you look, 29/11/2021. 20th of November, the sell deed was prepared.
20 November
2021.
2021. Into brackets, the date of draft sale deed. Draft sale deed. First one. Next paragraph. Both the sides agree that the matter be remitted to the portals of BDA, OPBDA, for consideration afresh by appointing an approved valuer of the income tax department, so that the market value of the site in question would be apportioned from that of the structure existing thereon for the purpose of payment of consent charges.
Consent fee.
Consent
fee or consent charge.
On account of intended transfer. First off, this exercise has to be accomplished within an outer limit of 6 weeks. First, depending upon the outcome, the refund has to be made proportionately,
if any, your lord,
to the
because
petitioner.
they may
Refund, if any, shall it be obviously to the petitioner without breaking any deal. Ordered accordingly, and the petition is disposed of. Little structure will undergo change, but this will be on. Okay.
So for that valuer is concerned, BDA will choose members or
yes, BDA will choose approved valuer of.
We'll ask the income tax department to.
Yes, they will give the name, and based upon that you can do that. The approver charges to be borne out by the petitioner himself.
Yes, ma'am.
Yes, yes, what is that? Any urgency?
The student evaluation matter, they have now just me give a counter.
They have given the counter to you.
Yes, but what I gather from that counter, they are saying, one second. They say that I have applied for 3 questions or 4 questions, but now I am come up with 8 more questions, which has not been evaluated because I have gone through that answer script what is supplied to me. And from that, I found some mistakes which I could have got marked, they have not given. if my lord will consider this aspect and direct my lord to reverse, whatever the fate will be of the student, that will be
You have got a very fair.
Yes. Yes, told me.
Sir, what can be done?
What I would like to please before your lordship is, before your, I will not, certainly not stand in your lordship's way to pass such orders. But before your lordship pass that order, my contention is that that three-tier system that I had stated before your lordship, that regarding obtaining of Xerox copies, then re-addition of marks, then re-evaluation of the evaluated answer sets. And in this case, all these three process is over. So in that view of the matter, at the prayer of the petitioner, that doesn't call for such a
interference.
That is my humble submission with your lordship. And if your lordship pleases also, we can produce the subject experts, because each re-evaluated papers were re-evaluated, checked by 2 subject experts in each paper. So that can be produced before your lordship, if your lordship pleases.
Just produce for my satisfaction.
Yes.
Because other day I saw there was a very abnormal mistakes, blunders by the evaluator. Therefore, though court knows the limitations in these matters, these are all matters pertaining to the campus.
Yes.
And court cannot much interfere.
Academic.
But it cannot close the eyes when it can decide the matter. Therefore, you produce the papers so that I'll just look into for my satisfaction. The student should not feel that court has not considered my grievance at all. For that satisfaction, I want to do that. All right.
As your lordship.
No order need be passed. Just you produce it and I'll just.
I'll do
it. To bring those documents.
That would be better. It would be better for me to convince my clients.
Record being had to the complexities involved in the case, it is desirable to see the answer sheets of the petitioner, subject answer sheets of the petitioner, who is raising the grievance as to abnormal undervaluation, stroke, non as the case may. First. Therefore, the learned senior panel counsel appearing for the university is requested.
For the CBSE.
CBSE is requested to produce in sealed cover the subject answer sheets for the perusal of the court. Okay.
I have filed out answer scripts also. Photocopy they have given me. Evaluation sheet, my lord, will call for that will better. Answer script I have given it.
Along with evaluation.
Yes.
That's evaluated answers.
Because I have given the answer.
Because the evaluated answer sheets have to be produced.
Evaluated answer sheet.
Yes, that will work.
My lord, call on 9th of February.
For 29, yes, next week is. Should be concerning. Of course. First week of September, if my learned friend will cooperate, my lord.
All right.
First week.
The 2nd of September?
Yes, sir.
Your lordship may say re-evaluated answer sheets.
Re-evaluated answer sheets. Okay.
I'll file the counter and the Vakalatnama in the
That is in the meanwhile, counter.
It is filed.
Also may. Counter is filed.
Yes,
no, I've served, but not filed yet. I'll file in the register.
In the meanwhile, counter to be. Okay.
Oblast.
Yes, next.
Madam Clerk.
Yes, Lordship's order. I have served the copy of my counter. I am appearing on behalf of open number 7.
Yes, Mr. Mukherjee,
but they have
that's absolutely wrong submission which is being made. If your Lordship just peruses the order sheet, it will reveal that on numerous occasions such a plea has been taken, and there are receipts available with me by which of the entire brief to each of the parties. Entire brief. Not only the writ petition, counter affidavit filed by the state government, the counter affidavit filed by the central government.
You want one more copy now?
No. Last again, your Lordship filed order dated 16/1/2025.
directed the Land Council for the state government to supply those letters which have been recommended to the OP number 7. So that I can get the instruction whether in our counter we have denied that we have not received such recommendation after 2018. They are taking a plea that they have recommended the petitioner.
My lord, the fact of the matter, confusion is created. I had initially filed the writ application challenging Annexure 1.
Annexure 1.
Annexure 1 to the writ petition.
7/8/23.
By which the granting aid in favor of the petitioner in child care institution was negatived. Now, during pendency of the writ application, hearing of the writ application, it was conceded by the state that that order is wrong. And hence, this honorable court granted them an opportunity to rehear the matter and pass an order. The order is under Annexure 25, which is also being assailed before your lordship by way of amendment to the writ application.
Having heard, they denied.
They denied. Now, Annexure 25 refers to certain letters. In Annexure 25, there are certain letters which are referred to, which allegedly the state government had served on the petitioner. Now, it is the categoric case of the petitioner that such letters have not seen the light of the day. In fact, I had written to them that please provide me copies of these letters, which you say are enclosures to the impugned order. They have given a reply thereto saying that there are no enclosures to the impugned order. Thereafter, my lords, before this honorable court, on numerous occasions, they have taken time that they will produce those letters. Not on one, but on numerous occasions. Those letters have not come because they are not in existence.
But they are referred to in the rejection order.
In the rejection.
Who had to give those letters?
It is the state government. The central government has
I am from the state government. Here, my lord, in pursuance to the order of this honorable court dated 16/1/2025, my lord.
16/1/25.
Yes, ma'am. It is directed that I should submit by way of an affidavit the certain documents and letters which has been duly communicated to the central government for the purpose of this aid, my lord. That I have received right now. I will file it in form of affidavit.
You at least you give copies to him.
No, right now I have downloaded. I will. With an affidavit.
Your lordship may kindly see, my lord, this is a child care institution.
Anyway, you don't want letters.
No, well, the letters, my lord, kindly refer to Annexure 25. Kindly see Annexure 25 for a minute, my lord, which is annexed before your lordship.
No, the letter he wants to give to you now.
Let him, my lords. I have the court directed him to give it. There is nothing stopping him from serving it. I have been waiting here since morning. Had he really had the intention of serving me, he would have done it by now.
Mr. Mohan, take them.
Copies. I'm today itself also. In form of affidavit also or raw copy also I can serve.
I will recall that you have given letters referred to in that impugned order.
Annexure 25.
It's a forwarding letter dated 9/8/2025.
How many letters you have referred to? How many you are giving?
Seats, How many seats,
No, letters, all letters which have been referred to. Just look into, whatever letter you have referred to in Annexure 25. All those letters, because you have structured your decision on that.
Yes.
You should know that.
Right now also in course of the
Can give it. I will be a witness to that.
I will make a copy of this. I have the copy.
Yes, see that.
Single copy I have downloaded.
Whether all letters are.
I will verify and return it back. 19/8/25. No, 19/8/25 is not. 7/3/2020. 7/3/2020. Okay.
Sometimes you give a lot of rest to the judges.
27/10/21.
Yes. 7/9/22.
7/9/22.
18/4/23.
18/4/23. 26/23.
7, 27, 10, 21. Which one আছে?
The letter referred to in that order of 27-10-21, which is not here.
Yes, Mr. One letter.
One letter. And apart from that, there is 18-4-23. 18-4-23 letter is also not there.
Two more letters you have to read.
27-10-21. 10-21. 18-4-23.
15.
And 15-9-2020. Three letters. No, 15-9-20-23 is not there. 20 is a resolution. That's not necessary.
Not necessary.
Not necessary.
So 18-4-23 letter and another is
27-10-2021.
27-10.
It is not.
Apart from whatever is
learned AGA pursuant to coordinate bench order dated 16-1-2025 has supplied the letters referred to in the impugned order at Annexure 25, except the two letters dated 27-10-2021 and 18-4-2023. First up, learned AGA undertakes to supply the same within 1 week to the learned for the petitioner.
Also to the Council for Officiating.
So, and also to the council appearing for
opposite party number 7.
OP7. OP7. Yes.
I'm returning this document. I'm returning the documents.
Why you are returning?
He doesn't have an extra set. He will prepare it and give it to me.
Is it?
That's what he said. That he has taken a download.
But I will not write that order, so that we will give that at least to you.
In course of the day.
Because I'm not
writing.
All right. The Lordship may only fix it.
Which date? In second week of
in 1 week, he is to serve on me.
On so 17-9 I will call this matter.
Yes.
Can it be the earlier week?
11, all right.
10th or
11th.
10th or 11th. 11th is fine.
11th.
11th, my lord is fixing that.
Other matters we have fixed.
So either a 10th or 12th, whichever is convenient.
No, on 16th we will have this matter.
16th.
Oh, because other matters we have fixed.
Exactly.
Okay. Item 51.
51, my lord. I'm sorry. I require some time more.
So we need that time.
The whole so many.
But definitely, G will not ask. Any government advocates will not ask time. In my court,
I require some more time so that
the whole difficulty, these people, they have not been allowed, despite the order passed by the Lordship, they should be allowed to continue. Still then they have terminated, and those persons were terminated themselves.
Dates may kindly be given so that because so many dates, so many orders.
On 9-9, you
9-9, yes, my lord.
9. Finally, call on 9-9 at the request of the AGA. Item 52. Item 52 has been adjourned. Item 53.
So,
Primary school teacher, my lord. Appointed in 1991. In 96 was directed to officiating the post of headmaster.
52. This is not you.
No. 53.
53.
Yes.
53.
53.
Yes.
I was officiating the post of headmaster, my lord. Then this Honorable Court directed at page 2 the other person to pay the officiating pay so long as in the officiating in the post of headmaster. Subsequently, regularly, I was promoted regularly in 2014. In page 22 the other, my lord. Direct second paragraph. Let's got it, my lord. Page 22.
is 22. Yes, 25 January 2018 order.
Yes, my lord. Second paragraph. The present petition, however, the present petitioner since continuing in service and he has already been promoted, he is entitled to get all the consequential service minutes from 8th October 1997. In the post. That
The officiating will have officiating allowance.
yes, allowance. As per the Supreme Court decision, madam, I am giving.
No. Service code is there by decision.
Yes.
There is a provision in the code. 96, 97, something like that.
Directed, which shall be paid to him within a period of 3 months.
They have not paid.
They have not paid. What they have in similar circumstances, they have paid to others, my lord. But in my case, in Annex 7, page 23, they made it notional. They calculated that, my lord, but they did not pay the actual payment. Actual payment they have made to others, my lord. In the counter, they say they have filed a review petition against the order, my lord. In the counter, my lord.
What happened to review petition?
The review petition, they have withdrawn it.
It is withdrawn.
They have
You have
withdrawn.
to make the payment to him also. You can't discriminate.
If others have been paid, he should not be discriminated. Well, duty pay is not the scale.
Not scale.
It's an allowance.
Allowance. Allowance has to be paid.
Some companies
Holding the charge of the
higher post. Higher post. Some amounts has to be paid.
In Annex of my last.
No, whatever they might have paid to others, we do not know. Your right to get the money is only allowance.
Officiating allowance.
Officiating.
Officiating.
Nothing beyond that.
Yes. Officiating allowance as a Supreme Court decision, the pay of the higher post.
That's the prayer now.
No. Higher post
Yes,
scaled up.
that is.
If higher post scale up,
means officiating.
my lord, if higher post, if we shall pay the salary of the higher post, my lord,
See the judgment
it
Supreme Court
amounts to
judgment.
holding the post.
He does not hold the post.
Yes,
It is an officiating arrangement.
I was
Mostly officiating, it is not the scale.
I was holding that post, my lord, on officiating basis.
You are in
You
charge
do
of
not
that post.
holding the post mean Apex Court said you should have right of lien to the post.
Exactly.
You do not have right of lien.
No, man.
You know, in charge and independent.
Yes,
charge.
yes.
These are all
Yes,
ideas which have been
different-
considered by the
different
standard
concept.
book on service law. When are you going to make the payment?
My lord, I do not know the position there. Lordship may give me some time. I will get instruction and come
No,
up.
there is an order now. For order compliance, no instruction.
My lord.
Compliance.
Yes.
This is an order.
Lordship, 2 weeks after your lordship may talk.
Learned counsel appearing for the petitioner draws attention of the court to a coordinate bench order dated, which is dated
Dated 25/1/2008.
No. This is 5/1/2024.
no
25/1/2018.
25/1/2018.
Page 22.
Yes,
Entered in
Yes.
WP number 20599 of
Yes.
2009,
Yes.
wherein a direction has been issued to the OPs to pay to the petitioner all consequential service benefits from 8th October 1997 within a period of 3 months. First, these consequential benefits are nothing but the charge allowances since the petitioner was placed in the charge of headmaster. Sans right of lien, although he has been promoted to the said post later.
Yes.
First time. At the request of learned EG, a period of 2 weeks is granted for reporting compliance of this direction, failing which the defense may be struck off in the petition. In addition to levying interest that may be recovered from the erring officials of the department. Okay. Call this matter on 9/9?
9/9 will be
16/9?
16/9.
Okay. Ensure, because I have made it clear now.
Let's see.
Otherwise, the order gives some other impression. I have just made it, I have clarified it in the light of norms of service jurisprudence.
Yes.
Okay. Before?
My lord, I'm on behalf of Mr. Sarkar, kindly adjourn for next week.
54. All right, 3 weeks at the request only. Item 55?
May I please, Elder?
Yes.
My lord, here I have challenged the order passed by the director under rejecting a case for regularization of service on the ground that I have passed bachelor's degree in education in special education. My lord, I was appointed as a contract trained graduate teacher on 1/7/2011. By facing due process of selection, there was an advertisement.
Advertisement dated?
That advertisement is Annexure 1. The dated is 20th November 2009. It was published in a local newspaper.
Pursuant to that, you applied.
Pursuant to that advertisement, I applied for the trained graduate post in CBZ, Chemistry, Botany and Zoology.
The teacher.
PG, trained graduate teacher. Trained graduate teacher.
Trained graduate teacher.
Teacher in CBZ. And your lordship may kindly go to Annexure 1 at page 17.
Clarify CBZ, PCM, these on teacher.
Yes. But so far as the same is concerned, in a 3-class high school, besides arts trained graduate teachers, there shall be one science trained graduate teacher in PCM, physics, chemistry and mathematics. And another is science trained graduate teacher in CBZ, chemistry, botany and zoology. I applied for the post of science trained graduate teacher in CBZ pursuant to the advertisement under Annexure 1. Your lordship may kindly, for a moment, your lordship may kindly glance at the very advertisement itself. What is the qualification prescribed in that advertisement? My lord may kindly see clause 2.
No, you were appointed on which date?
My lord, I was appointed on 1/7/2011. Annexure 2. On contractual basis. And my contract was renewed from time to time. I have given all the extension orders, renewal orders.
Up to
till today I am continuing. Of course, by virtue of the interim order passed by this honorable court, my lord, after the rejection order was passed, the interim order was passed on 11/7/2024, directing for maintenance of status quo. And I have been continuing.
You have been continuing. And you have been paid also.
I have been paid, but from March 2025 onwards, I have not been paid. Therefore, I have filed one IA.
Why not paid, brother? If he is continuing as a teacher, non-payment will be violation of Article 23.
My lord, but I have no instruction whether he has received.
No, he is saying he has filed application itself.
Yes. And earlier there was an order.
23 of Article 23 of the Constitution enacts doctrine against beggar.
My lord.
Perhaps that's the only Indian word employed in our Constitution. Beggar is defined, which Shirwai mentioned 2 judgments in constitutional law. Beggar means making payment less than what one is entitled to, that is underpayment. or non-payment. There is one judgment of the apex court. State of Rajasthan versus Honorable High Court of, State of Gujarat versus Honorable High Court of Gujarat, where this aspect is considered. You can't make any employee. They said even prisoners who were serving sentences, if they are made to work in the jail, they should be paid.
They are also getting.
Then you cannot deny this to client of Mr. Swain.
And there is an order to that effect also. That order was passed on 28/1/2025 in another IA. Your Lordship may kindly see that order. The operative portion of that order is
25/1.
That is 28/1/2025. My Lord directed, the coordinate bench of this Honorable Court directed that if I am discharging my duties, my salary shall be paid. And accordingly they paid. But from March 2025 onwards, I have not got a single pie.
As you get salary every month, they want order also every month.
Let me
Call this matter on 21st.
21st, my lord. 21st of this month.
2nd of September.
Very short time, my lord. I am to get instructions.
2nd of September.
2nd of September, yes. 2nd, 3rd, I'll get.
Call on 2nd of September for reporting compliance of order dated
28/1/2025.
28/1/2025. In as much as petitioner is said not to have been paid for the month of March
2025 onwards.
2025.
Yes. Interim order to continue.
Interim order to continue. The respondents are warned that in the event interim order is not complied with, the defense may be struck off and the petition prayer may be allowed as it is.
Item 56. Please, Grievance. Whereas in this matter, I have impugned a notification passed by the university, and I have been redesignated as an associate professor after 5 years from my appointment as reader, which is, my lords, directly in teeth of an order passed by this honorable court, a judgment of this honorable court, wherein a rule 7 of the UGC scale of pay rules was interpreted, wherein this honorable court has said that the UGC 2010 rules, which has been adopted by the Orissa government, as per that rule, the readers who were appointed before 2010 would have to comply with the 5-year period before they are redesignated in the scale of pay of associate professor. But the said rule cannot be interpreted to include readers who have been directly appointed after 2010, because that 5-year period was only for those teachers
who were not appointed as associate professor.
Before 2000. So that the 2010 is the watershed period. So pre-2010, you do not have to comply 5-year period.
You are appointed post 2000.
Post 2000. 2014 is when I'm appointed. So as per the UGC regulation and as per the judgment of this honorable court, which was confirmed by the honorable Supreme Court, my redesignation should have been from 2014.
From the date of appointment.
From date of appointment as a reader. So that is, my lords, the short point.
Earlier it was assistant lecturer,
reader, professor.
Lecturer, reader, professor. It became assistant professor, associate professor,
and professor
emeritus.
Professor emeritus. There is, I'm subject to correction, there is, I believe, a senior professor also in certain universities.
So, no, professor, senior scale.
Senior scale.
What is? I am for OP number 2. I need to file counter.
This is
2020, which year matter? It was 2024, my lords. The urgency, my lords, is this. And my lords, I'll be.
Mr. My lord, your lordship may kindly see page 14, Annexure 1.
14 Annexure 1.
Yes.
You are ready now for argument without counter.
No. I have some points in my case.
You can't argue in installments.
Yes. Your lordship may
You are not
give me time for counter.
No, under your rule, only 1 week is prescribed for filing the counter. Rule 11. Although it is a weak rule, it gives 1 week for filing your counter.
That's why I am placing the case, my lord.
No, let us file counter.
Annexure 1.
Counter the file.
Why you did not file the counter? What I should do with Annexure 1? I should take the petition and follow the petition.
State government counter is necessary, my lord.
You don't worry about it. Then you say you will not file the counter.
No, we will file counter.
That you should not have done.
We will need time, madam.
3 days time will be given for filing the counter because already. Yes, sir. You don't want to file the counter?
Yes, we have to.
This is a
Matter of 2024. I'm conscious of
case of 2024. First, the extant rules prescribe 1 week for filing of.
This is past time and
more than one. That is not the question. More than a year has lapsed, and still counter is not filed by the OPs. First, as a last chance, 1 week is granted for filing the counter after serving copies thereof on the counsel for the petitioner. Failing which, right to file one stands forfeited and the petition averment should be taken up with face value. Don't call this matter on
Can I request first week of September if possible? If my lord's calendar
have difficulty because
present
5th is again holiday.
Please.
That's the reason.
Please, 10th. I'm grateful.
257.
Yeah.
Item 57.
None appears for petitioner. Call after 4 weeks. Whenever
I am
counsel for the
petitioner.
You appear for the petitioner.
I am for the petitioner.
Yes. Tell me.
They have to file counter that they reflected in the court side. Counter that already been filed, but that is not short on me.
Give copy.
My lord, I'll give. Just now, I'll give.
Call after 2 weeks. Next, with the request one.
Item 58.
That the petitioner has filed his petition challenging the non-considerations of the applications of the Child Welfare Committee Bhadra. As she had given an representation to rescue her child, minor girl, about 13 years old, but they are not responding till now. And the honorable
Similar order, some order, we have treated similar matters where we have directed the jurisdictional police to take immediate. The other day, your friend Mohanty appeared in that matter.
My lord, here is a case. He is suggesting that his children should be taken care of by a child care unit because they are very poor. They are very poor to maintain their children. That's why. And
If you are poor, why did you beget the children?
no, Milord. The petitioner is a handicapped person, and he has given a representation to the concerned CWC Bhadrak regarding to inquire this matter and keep necessary action for the child. And the girl child, they have no house at all, and they are living at a in a government land.
Suppose tomorrow everybody produce children produces children and asks the state to look after. Do we have that facility?
No, my lord,
Before getting married, you should have thought of.
Yes.
At least before getting the children, you should have thought of.
After the children are birth, the petitioner is handicapped and he has house.
No, he does not appear to be handicapped. Here, more powerful person. He has got children and married children. Which right? Which is that right? There is one judgment which says no such right is available.
Not the child is common.
Then people do start doing that. I can beget children so that others will look after my children. That is contrary to the state policy.
The child is common under the CNCP. The child need for care and protection.
They are not these children.
These children are
Not my children and your children. It is for some special category children.
The child is living at the street with the help of an NGO, and now she is she has admitted in a hostel. It is not responsible for the state to keep her in a safe place.
Oh, whose responsibility it is? The parent has no responsibility.
If parents have no responsibility, then who can?
Once children are begotten, it is over. All they belong to the state.
Not they are houseless.
That makes no sense. That I will be laying down a dangerous precedent. Tomorrow, everybody will press into service this judgment. No, I am rejecting this.
The child is.
No, why did you beget the children? If you are a poor man, if you are a lame, or you are handicapped, why did you go for marriage at all?
The person have no house at all.
Therefore, you should not have married. At least you should not have begotten the children. What? They were just playing happy. You have pulled them down to the earth where things are not that ideal. And now you want the state aid. State should look after your children. If we make one such order, that will become wreaking havoc. Already we are 141 crore people. And tomorrow, if state is going to look after the children, India will become full of children.
What about the child? Because he has no fault and he has a student and he can bring at the footpath.
Well, why did you do that? You work 24 hours and build a house for her.
Not just to provide safety and security to the girl child, I have filed this petition.
And that cannot be given. We'll be laying down a very dangerous precedent. Unless you show which law says, if person is poor and he has begotten children, those children should be looked after by the state. Show them.
As the person I am houseless.
You have said it about 4 or 5 times. It appears you have 3 or 4 houses. You show the law. No right, no read.
I'll take some time.
Call after 4 weeks. Yes. The request of.
Item 59.
My lord, so item 59 is still time to file counter, my lord.
2 weeks for filing counter, reluctantly granted. Filing which the right to file one stands forfeited and the petition arguments may be taken with the face value. Yes.
Item 60.
None appears. Call up to 4 weeks. 62.
Item 61.
61 appears?
No.
You are appearing?
Yes.
For in 61?
For item 60.
60?
Yes.
Yeah.
I'm here for the petitioner, my lordship. The petitioner challenges the decision of Central University Odisha for rejecting his appointment as the associate professor in the Department of Management. In their decision, they have said, I don't have the
minimum teaching experience, but I do. But
The teaching experience required.
teaching experience required is 8 years.
8 years. Where is that clause in the advertisement or in the rule?
Annexure 1.
Who is your opponent? Who is your opponent friend?
UGC, Central University Odisha, and
My lords, this is Central University. They have their own panel.
Any name is shown? Notice has not been issued.
notice has been issued, but no one is appearing for them.
They don't care for notice at all. Who appears for the OPs? Panel council are there?
Yes, for Central University panel council is there. UGC also panel council.
Tell the names. Despite service of notice, there is no representation from the side of OPs. Full stop. Petitioner to serve copy of the petition along with all the documents of the panel advocates who usually represent the OPs. Call after 4 weeks. Yes. Item 62. Count has not been filed. You don't want to file the counter.
And let's we have received the instruction and file it.
3 weeks for filing counter, finally. Filing which sides to signs. Yes. And then file counter.
Matter has become, with the Lordship's permission, matter has virtually become academic now. Because the order which was under challenge, there was no interim order granted by the General Court. Now that order has been implemented. The subject, well, let them file their. I am also appearing for the person to whom he had already handed over the charges.
Who is for the petitioner?
But he is for the petitioner.
Your friend is saying it has become infructuous now. You will file counter. They have to file the counter. Okay.
Oh, bless.
63.
In item 63 is the matter relating to regularization service PT, my lord, physical education teacher.
Physical education teacher.
Yes.
How many years of service he has?
Since 2007 onwards.
2007.
Yes.
18 years.
18 years. And when this Honorable Court in an earlier occasion directed for consideration,
they rejected it.
They rejected it.
On what ground?
On the ground that the petitioner had not properly selected as per the proper procedure. At page number 72.
What do you say, brother?
Well, let's
what is that? For 18 years, having taken his services, if you say, no, the marriage was not properly performed and therefore children are illegitimate.
Well, let's file counters.
Counter.
One IA I have filed, my lord. Then the post in which I am continuing, the sanction post, that should not be filled up.
An application is moved, supported by affidavit, seeking an order to restrain filling up of the post against which the petitioner is working. Full stop. If post in question is filled up, comma, petitioner may be put to prejudice. Full stop. If not filled up, prejudice will be caused to anyone, in as much as matter would be taken up soon after filing of the counter. Full stop. Next, in the above circumstances, the subject post shall not be filled up without leave of the court. Full stop. Violation of this order may result into striking of the defense of the respondents. Yes.
Short date may be fixed for filing of counter by district.
Calling the 18-9. Where interim orders are not implemented, any government advocates, private, etc., I will strike off the defense. I will straightway allow the petition on that ground itself. Yes. All right. The rest of the matter distributives.
Item 64, can it come up tomorrow, man?
64. What's the urgency?
The urgencies we have filed IAs. We were, my lords, IA for bringing on record the termination order, my lords. Initially, we were put under suspension. We are a contractor, my lords. We were put under suspension and thereafter we have been blacklisted. So we are bringing only for the limited purpose of bringing it on record, my lords. If it comes up tomorrow, my lords, we will.
Tomorrow we have difficulty. We have posted many.
Let them serve copies. We are on aviate in this matter.
No, sir.
Yes, at least serve the copy.
Let them serve copies.
All right. Call on 4-9.
On 4-9, my lords. Can it be 3-9, my lords? 4th I'll be leaving, my lords.
3.
My lord may say that let them serve copies.
Yes, we will serve.
You are giving it.
My lords, we will not deprive him of the copy.
Rest of team.
Item number
67.
67.
67. It's 25 matters.
So it should be coming the Monday.
RSV similar matter already posted.
Similar matters are coming on Monday.
25th.
Call this. All right.
Obliged.